Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case.
That crap.
Dati mihianggoy ka po.
That's literally not true.
I didn't ask you to interrupt me. Oh, for Trump's sake.
Oh my goodness, so many buttons to push, but we managed to get all of them, I think. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Looks like a few of you made the jump over. We're in, I said part 3. Is it part 3? 1, 2, yeah, we're in part 3, which will be the final part of this trial. We had to leave because YouTube didn't like us. That's it.
The zombie apocalypse may be upon us.
All right, we'll turn that down just a little bit. And as we get set to start what is day 2 of the trial.
I would lose my mind.
I would lose my mind. Gail Pett says, just watch a commercial for old lady bras. There you go. So we're monetized again. That's the good news, Gail Pett. Thank you. Chat not on the screen. I'll put it back
Shame
up.
on you, sir.
Thank you. Kim R., first in chat this afternoon, or this morning still. I guess it's still morning. Congratulations, Kim. Please explain why you did what you did. Teresa, yeah, basically, as far as YouTube goes, we're all good again. We've separated out this video.
I was kicked back, taking it easy.
And we did it for a couple of reasons. First of all, it breaks up the day. If people don't want to watch like all 9 hours in one block, it breaks the video into different days. They can watch part 1, part 2, and part 3 separately. That helps them. It helps us as well. We like to keep our streams under 6 hours.
Blame the jury.
Because it gives us opportunities after the stream, if there is a problem, to go back and edit it. Anything over 6 hours, I'm not able to edit, and I just have to delete the entire stream if there was a problem. So there's a couple reasons, and it does turn back on monetization. So now, people are able to monetarily support the channel just by watching it and doing nothing else, and that helps us. And so yes, it's a financial benefit to me, which honestly, if it didn't pay me a little bit of money for doing this, I wouldn't be able to keep doing it for a long time. But thank you very much. Karen Dietrich says, best host Scott, best mods, and most generous chat on YouTube. 100%. Karen, 14 months, Karen. 14 months. Thank you so much. All right, we are ready to kick off part number 2. By the way, Kim, welcome. You won the internet. You do your thing. Congratulations. We're adding this to your permanent record. I think I'm on page 6, by the way, as far as your record of how many times you've won. So definitely a habitual offender there. Reverend Beasy, thank you, Ricky C., for my 15th month. There it is, Reverend, and thank you, Ricky. It was nice, Beasy, to see that gift come to you today. That was really sweet. All right. Those were some tough pictures. Those are some tough pictures from the autopsy. I think we're done with looking at those. And now we pretty much, that's the way this case is going. It's turning into, thank you for sending me your sore throat. I'm sorry, Twubble. That's why I use this filter, so that the sore throat can't go through into your ears and again to your, sorry you're feeling that bad. I would send you some cough drops. I've got 1 billion of them now. Teresa Super says, so cool. 3 whole months. I still feel like a rookie, though. Teresa, you're right at home. And you might be fairly new here, but you can never leave. So pretty soon you'll be here for a long time, and you'll know it. Kim is in charge of fixing the global internet outage. Yes, she is. Hopefully she can fix some of our commands, like the seat commands. It works sometimes, and it doesn't work other times. As we see people like Michaela and Laura are trying to take a seat here, and we're hoping that the bot the bot bailiff will usher them to their seats here shortly. It's just going slowly. Cachette pops some coins in the tip jar. Thank you very much, Cachette, one of our great mods and a great supporter on the technical side of YouTube for me. Thank you. All right, let's without further ado, let's begin court. All right, over here. The courtroom itself is not very crowded.
On our jump computer.
And we don't see the defendant.
Make sure you open the right.
I've never had a case where we don't see the defendant at all.
Two
but so far,
so
nothing.
The first one.
Standing room only.
Number 2 is yeah, delete it. Delete it offline just in case.
The girl with the animals. Welcome.
He did that because he did cool. Thank
you very much for the super chat and the kind words.
Where's Vicky?
Oh, right here. I'm not sure if there's going to be any more.
This is Judge Scott McAfee, I believe, in Fulton County, Georgia. Sam J. in Ireland. Welcome, Sam.
When I was out there, I did see one juror coming in, so I don't know if that's the last one we're waiting. Where's Nathan? Okay.
Bertie, I'm sorry.
They want my desk?
The portal was supposed to work, but for some people it doesn't. I don't know why.
All right, looks like we have a light on, so why don't we have your witness come up to the stand? We'll bring him out.
Oh, they have a light system, like a paging system for the jury. That's cool. That voice you hear in the background is Mrs. R.A. reading to the kids, and she does a very animated reading. And the kids love it. They sit enthralled. But sometimes it carries over into the live stream here. I think she's reading something from the Little House on the Prairie series right now. Josh Hutchings, thank you very much for the super sticker. Big super sticker. You are amazing. Josh, you are as well. Janie, I wish it were easier to do that. Reading books on the internet that are copyright is a quick way to get permanently banned, and which is terrible because I think YouTube is a great format to read to somebody, and I wish there was a way you could make an agreement with the copyright holder to read books, but no, they're worried about selling physical copies, and so anytime you read a copyrighted book, you get a ban. There's no fair use of reading a book to someone. You can read an excerpt, but that's about it.
Thank you, Deputy Scott. Welcome back, members of the jury. There aren't any concerns that we need to address. Statement calls next witness.
State calls Investigator Smallwood.
Thank you, right here, please. Do you swear for testimony to be in court is the truth and nothing but the truth to help you? Yes, you may, student. Please state the spirit of the first and last name of the court.
I'm Sergeant Gary Smallwood, Gary Smallwood.
I'm sorry, I said Investigator Smallwood. Are you not an investigator anymore?
No, I've been promoted.
Okay. So being a sergeant is a promotion.
Correct.
Okay, all right. Can you just please explain to the jury, how are you employed?
With the City of Atlanta Police Department.
And how long have you been employed with the City of Atlanta?
About 14 years.
And what are your duties currently as a sergeant with the City of Atlanta?
Just to supervise, monitor, and delegate responsibilities as a supervisor of City of Atlanta Police Department.
Okay. Of other police officers?
Correct.
Okay. And are you post certified?
Yes.
Okay.
Diana
and,
Beatson, thank you for the super chat. Thank you so much.
Well, let me jump back to this. In October of 2020, how were you employed?
At that time, I was at the rank of investigator with the City of Atlanta Police Department.
Okay. And what were some of your duties as an investigator with the City of Atlanta?
As an investigator, I get assigned cases or current active cases, get called out to the scene and investigate and see what's going on and try to solve the crime.
What types of crimes?
I was with the major crimes unit, so I investigated shootings, aggravated assaults.
Okay. And back in October October 26th of 2020, did you happen to respond to a 878 Norwood Road?
That's correct.
Okay. And why did you respond there?
I responded there because dispatch officers for a person shot at that location.
Okay. So when you got to 878 Norwood, what type of location was that?
It's kind of like a convenience store or a little small plaza.
Okay. And did you speak to anybody at that particular location?
Yes.
Okay. Who did you speak to at that location?
I spoke to Jamon Johnson.
Okay. At some point in time, did you understand that Jamon Johnson had left that location?
Yes.
Okay. All right. And did you have him come back to that location?
Yes.
Okay. All right. At that time, was Mr. Johnson under arrest?
No.
Okay. And was he suspected of committing a crime at that time?
No.
What did Mr. Johnson tell you in regards to the incident?
That he was sitting in the vehicle, him and his friend, Jacob Ingram, and somebody tried to rob them, and he had to defend himself. The suspect had a gun and pointed it in the car, so he ultimately ended up firing his weapon in defense.
Okay. And did he tell you, did he fire that weapon inside of the vehicle?
He said it started inside of the vehicle, and he kept firing until he felt he was safe.
Okay. Did he ultimately get out of the vehicle?
Yes.
Were you able to review any surveillance cameras from that location?
Yes.
Okay.
Josh, thank
And,
you. We've got about 20 minutes of this view, which will show.
Were you able to see the incident take place on surveillance?
Yes.
Okay. Were you able to see the events as Mr. Johnson described them?
Yes.
Okay. I'm going to show you what's been marked as State's Exhibit 116.
Creative B, Debbie, welcome back from vacation. Send us pictures.
Do you recognize State's Exhibit 116?
Yes.
16 months.
And what do you recognize it to be?
The victim's vehicle and Mr. Johnson, from how he described him defending himself, it appears that he's shooting.
Okay. And is this a screenshot taken from that body camera? Or it's not body camera, but surveillance camera?
Surveillance camera, yes.
Okay. And is it a fair and accurate depiction of Mr. Johnson shooting his firearm?
Yes.
All right. At this time, State tenders State's Exhibit 116 into evidence.
No objection.
116 is admitted.
Okay. At some point in time, and can you just show 116, please? Thank you. While that's pulling up, at some point in time, were you able to look for, or were you able to see any evidence that would help you in trying to solve this particular case?
Yes.
Okay. What did you see?
Broken glass and shell casings located in the parking lot.
I'm sorry?
Shell casings located in the parking lot.
Okay. And particularly, where were those shell casings that you located? Where were they?
They're on the outside in the parking lot from where the vehicle possibly was, the victim's vehicle.
Okay. I'm going to show you State's Exhibit 48 through 59.
We should get to see all these pictures, and then after about 20 minutes, we'll get
I think we need to
our camera views back.
To publish.
Which username?
Mr. Wright.
All right, if we could make Mr. Wright a co-host on Zoom.
Do you recognize State's Exhibit 48 through 59?
Our seats aren't working at all.
116, yes.
I'll reach out to Lumia Stream, but I think it's something on their end. We've bounced them several times.
Do you recognize State's Exhibit 48 through 59?
Yes.
Okay. All right. We'll pause right there for a second, but we'll go back. We'll go to State's Exhibit 116. What kind of car did the defendant tell you he was driving?
A gray Acura TL.
Okay. Is that what's depicted here in this particular video or screenshot?
Yes, it appears so.
Okay. And at some point you arrived on the scene. Were you able to locate any shell casings?
878 Norwood, correct.
Okay. Yeah. All right. Can you just point behind you where you were able to locate some of those shell casings?
Kind of in this area right here.
Okay. All right. Let's go back. Thank you.
Point. He's got a touch
If we
screen.
could,
Just point
please,
to the TV instead.
you recognize State's Exhibit 48 through 59, correct?
Yes.
And how do you recognize them?
As being the incident location that I arrived to investigate the crime or the scene.
All right. And are those photographs of that scene?
Yes.
Okay. Are they fair and accurate copies or depictions of that scene as you saw them?
Yes.
All right. State tenders State's Exhibit 48 through 59 into evidence.
No objection.
48 through 59 are admitted.
I'm going to show you what's been marked as State's Exhibit 84. Now, when you're investigating, do you happen to have help investigating your particular crime?
Yes.
And who are the people that help you investigate?
Other officers and then crime scene technicians have to come out and take photographs and collect evidence.
As a investigator, are you the leader or the director of the crime scene?
Sort of, yeah.
Okay, all right. So you would help or direct people to do certain things or collect specific evidence?
That's correct.
All right. I'm showing you what's been marked as State's Exhibit 84, correct? It's 84, right?
84, yes.
Do you recognize State's Exhibit 84?
Yes.
All right. What is State's Exhibit 84?
It's shell casings that was collected and turned into evidence.
Okay. They were packaged in that brown paper bag?
Correct.
All right. State tender State's Exhibit 84 into evidence.
No objection.
Admitted.
All right. So let's go to State's Exhibit 48 through 59, please. Can we publish it? Yes, please. Okay. What are we seeing right here?
That's the location, the incident location.
All right. Can we go to the next slide, please? Is that 878 Norwood?
Correct.
Is that located in Fulton County?
Yes.
Okay. Do you typically work this zone or this area? Or did you typically work this zone or area?
Well, as an investigator, I'm over the whole city.
Okay. All right. Next slide, please. And let me ask you, is this located in Fulton County?
Yes.
Okay. If we could zoom in, please. All right. What do we have here in State's Exhibit 50?
Just yellow markers showing where the possible shell casings were located.
Okay. And when those markers, they track with each of the projectiles found in Exhibit 84?
Yes.
Okay. All right. All right. Next slide, please. Actually, can we stay on this? And where was the car? I know we have the screenshot in number 116, but where was that car located? If you
it appears from the incident, the car was located somewhere in that vicinity.
Okay. All right. If we can go to the next slide, please. Now, exhibits exhibit number 51 and the rest of the exhibits are all shell casings like this, correct?
Yes.
Okay. And they just show a shell casing and where they were found and the marker number. Is that right?
Yes.
All right. No mark. All right. Okay. When speaking to Jamon Johnson, what did he say what he did with that firearm?
He said as they were leaving the incident location, he threw the Glock 9mm out the window.
Okay. But he told you it was a Glock 9mm?
Yes.
All right. Was there a time period between the time that you or officers first encountered Mr. Johnson and this particular incident?
Correct.
Okay. All right. And you said that he went into a home on Thomasville Road. Is that right?
Yeah, he went to the address 1759 Thomasville Drive.
I know at some point in time, can you describe your efforts in searching for this weapon?
The officers requested K9 to come out there and kind of canvass the area, see if he can do an article search and locate the weapon, but they were unsuccessful.
Okay. All right. At any point, did anybody go inside of that Thomasville Road house and search that house for that weapon?
No, I don't believe so.
All right. I think that's all. No further questions. Thank you.
Cross-examination.
So far, the cross-examination has been limited to like caliber size, and can you confirm it was my...
Mr. Johnson, you said that he referred to the weapon as his weapon. Did he actually say it was his weapon or someone else's weapon?
I don't recall that.
Okay, all right. And he said he told you that he threw the Glock 9mm out of the window. Did he say where where he was when he threw it out the window?
There's like a bridge, like a street, like a bridge. And he said he just threw it out the window. And then that's where we searched the area where he pointed to where he possibly threw the gun out.
Yes, sir. So, and you said it was 9mm Glock. So were all the shell casings that were located 9mm?
I believe so. I don't see in the report that it shows any other type of caliber.
How many shell cases is in that package?
It's 9.
Okay. And does the package indicate that all those shell cases are 9mm?
Yes.
Okay. Thank you.
Can you redirect?
You spoke to Mr. Johnson. You saw him that evening.
Yes.
Do you see Mr. Johnson in the courtroom today?
Yes.
All right. And can you please point him out by an article of clothing he's wearing?
He's to the left of me at the desk wearing black with the black male with the dreads.
All right. Let the record reflect that this witness has identified the defendant. Thank you.
The record will so reflect. Can this witness be excused, Ms. Russell?
Yes, Your Honor.
Mr. Brown?
Yes, Your Honor.
All right. Thank you.
The victim in this case went to the convenience store to buy mustard.
You can leave the exhibits there. We'll take care of them.
Walked out and was gunned down.
All right. Statement calls. Next witness.
Allegedly, this defendant and his co-defendant in a different trial. They fired 13 rounds. 12 of them hit. 2 of them on their own were fatal. The others were, several others were extremely serious. Had they been the only shot. We believe that this was retaliation for a shooting or an incident, a robbery that happened about a month prior. In that robbery the month prior, the defendant in this case fired his gun in self-defense, he says. But then he said he threw that gun after that off a bridge. But the shell casings, as far as which we'll hear, the shell casings.
Good morning. My name is Mark Tanner, MarkTanner.
Good morning, Mr. Tanner.
Good morning.
Please introduce yourself, or let me ask you this. What is your occupation right now?
I'm currently a firearms and tool marks examiner at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, also known as the ATF, in Huntsville, Alabama.
Okay. And what currently are your duties?
So currently my duties involve working on the NIBIN system, which is the National Integrated Ballistics Information Network, where we service the entire nation, linking gun crimes and gun shooting incidences across the nation. And I'm the firearms and tool marks examiner on site for the second shift over in Huntsville.
How long have you been a firearm and tool mark examiner?
It's 8.5 years.
Okay. Prior to that, what did you do?
Prior to ATF or prior to firearms and tool marks?
Excuse me, ATF.
Prior to ATF, I worked at the Georgia Bureau of Investigation here in Atlanta as a firearms and tool marks examiner, and I started there in 2016 and worked until a year ago.
So can you explain what type of training you have to do to become a firearm and tool mark examiner?
Yes. So the requirements for the GBI is to hold a physical science degree. So I have a bachelor's of science in chemistry from Armstrong State University down in Savannah. I then I got hired on at the GBI and began a 2-year training program. This consisted of learning ammunition components, firearms operation and safety, and then microscopic comparison of bullets and cartridge cases. I did then serial number restoration on firearms, distance determination of shooter to clothing, and then I did tool mark analysis on like wire snips and bolt cutters and such. That first 13 months ended, and then I began a 7-month period where I would work normal casework under the direct supervision of a fully trained examiner called the supervised casework. I would, cases from agencies such as Fulton County would come into the door, and I would work them, hand them off to a second trained examiner, and they would completely rework it. At the completion of that 7 months, I began my verification and peer review training. So verification is where a second examiner will fully rework a case on the comparison aspect and then render their own conclusions and compare it to the primary analysts. Then the peer reviewer will go through all the documentation, ensuring everything was done properly per GBI policy. After that long 2 years, I became an independent examiner where I worked in that position until I left for the ATF.
How many times have you compared shell casings and projectiles? Or in total?
So at the GBI, I did about 750 to 800 cases, and that ranged in one cartridge case up to anywhere around 50 cartridge cases, depending on the situation. Since I got to the ATF, I've done thousands.
Okay. Have you ever testified as an expert witness before?
I have.
How many times?
89.
So this would be number 90 if you are tendered as an expert.
If tendered, this would be 90.
Okay. In what counties have you testified as an expert?
Multiple counties throughout Georgia, all of them being in Georgia.
Right. And what fields were you tendered as an expert in?
Firearms examination.
All right. Your Honor, at this time, state tenders Mr. Mark Tanner as an expert in firearm examination.
No objection, Your Honor.
State may proceed.
Okay. Briefly, because I know this can be long, but can you just explain to the jury how a firearm works?
So a firearm has a trigger mechanism that connects in some way to a firing pin. When the trigger is pulled, the firing pin strikes the cartridge or the unfired ammunition. It will strike the primer on it. That primer creates a spark, ignites the gunpowder. the cartridge will combust and it will send the projectile downrange. Depending on the firearm, the cartridge case will stay in the firearm or it will be ejected from the firearm.
And specifically that cartridge case, if it is ejected from a firearm, what type of firearms are those?
So those would be what I would call a pistol. So handgun has two different types of firearms. It has a revolver and a pistol. So the revolver has the central axis and the cartridge cases will stay in. What she asked about the ones that eject, what we call pistols. Whoa. They have the slide on the top that'll move rearward and forward, and the cartridge case will be extracted from the chamber and ejected from the firearm.
Okay.
We're going to pause for just a second. We've got some news. We've got some news. American Airlines, United, and Delta Airlines have just implemented a global ground stop on all flights due to the current significant Microsoft outage that is occurring. I hope you weren't planning on traveling. Oh my goodness. We've seen some pictures this morning of just chaos, and I didn't bring it to you. Just chaos at airports, just huge lines. Now a full ground stop for American Airlines, United, and Delta Airlines, 3 of the largest carriers here in the United States. Wow.
This, as an expert,
aren't you glad
in your
we're here
field,
instead of at the airport?
When cartridge cases are ejected, where do they usually go?
Generally, for most firearms, it's going to be right in rear of the firearm.
Right in rear of the firearm.
Correct.
Okay. So if a person is standing one way, it just depends on where they're pointing the firearm at.
It depends on how the firearm is being held and in which direction it's being pointed.
Okay. All right.
Our seats don't work because of that.
Let me direct your attention to the GBI case number 2021-1000-207. Do you know if you conducted any testing in that particular GBI case number?
I did.
Okay. What testing, if any, did you perform?
So I did basic firearms analysis. So I compared bullets and cartridge cases to firearms submitted and then to the evidence itself.
Okay. Did you do any, and did you memorialize your findings in a report?
I did.
Okay. I'm showing you what's been marked as State's Exhibit 64.
Kim R. is in charge. Kim, it's going to be a big day for you. Seat is working.
Okay.
Kim fixed it.
Do you recognize State's Exhibit 64?
I do.
It's
and how do you recognize this?
So there's the GBI case number
right
or
now.
DOF's case number at the top right of the case, and then on the third page is my signature with my title.
And is this report a fair and accurate copy of the report that you created?
It appeared so, yes.
Okay. At this time, State tenders State's Exhibit 64 into evidence.
No objection.
64 is admitted.
All right.
Laura Fry, thanks for the
Can we publish,
the
Your
super
Honor?
chat via Cash App. Thank you very much.
Okay. All right. So this is a 3-page report. It's pretty long, or it's actually 2 pages. Excuse me. It's a pretty long report for your standards, or usually what you create. Correct.
Yes, this is a more on the lengthier side for reports.
Okay. All right. So if we could first just talk about where it says case individuals, what does that particularly mean to you?
Case individuals is simply the names placed on the submission form by the submitting agencies, and we just put it there for documentation purposes.
Okay. Under that, we see something saying evidence. Can you describe or explain to the jury? Can you zoom in, please, a little bit? Thank you. Can you explain to the jury? I see. It looks like 3 different groupings here. What those 3 different groupings are?
Okay, so when looking at this evidence section, you have a date at which the evidence was submitted and which agency submitted it. For court clarification here, in that first line, it says evidence from Fulton County District Attorney Jay Rickman. The Jay Rickman was a bug at the GBI's facility that we were trying to problem solve at the time this case was in the system. So they're unsure how that name even got on the report. I'm just being completely honest with you guys. So Jay Rickman has no relevance to that situation. Okay, it was just simply a computer bug. Okay, so you have the date and the agency that submitted it in each of the separate little sections. And then on the left side, you're gonna see the GBI case number followed by a dash with the GBI item number. So for instance, the first one, 2021-1000-207, that's the case number. And then -005 would be the GBI item number. So you have that first section submitted by one agency, the second section submitted by a second agency, and then the third section is actually a second case submitted by Fulton County DA's office. That's just how GBI lays out the reports for the evidence section.
Through the process that you examine all of these items, were you able to determine at all which case numbers, and it looks like 100207 and 10333844, were you able to determine, or do you know anything about those case numbers?
I do.
Okay. Do you mind just explaining that to the jury?
So based on the submission forms for these cases, the 100207 was a murder that occurred and evidence collected at that murder scene. And then the second case number, 2021-1033844, was a second incident that occurred prior. And from my understanding, it was an attempted robbery.
All right. So essentially and it looks like the district attorney's office, my office, asked you to compare one case to another case.
Correct.
Okay. And not only one case to another case, but there may have been other items. And if we go to the top here, not to the top, but item 005, which is a what?
So 005 is a Smith & Wesson 9mm pistol.
Okay. So that was asked to be compared to some of the items not only found on the murder scene, but elsewhere as well?
Yes. It was when we receive evidence at the lab, the agencies just simply request firearms analysis, and we compare everything to each other, trying to see if anything links to anything. Okay. And so I compared it as best as I could to everything related.
Okay. All right. I want to go to, in that top paragraph, items 006A and 006B.
Okay.
And I'll specifically start with 006B. That 006B, what was that?
So 6B was 9mm cartridge cases. And again, these were found at the murder scene.
And you received all of this, correct?
I did, yes.
Sure. Handing you what were previously tendered as State's Exhibit 120. Do you recognize State's Exhibit 120?
I do.
And how do you recognize that?
State's Exhibit 120 I recognize because it has the GBI case number, it has the item number, the barcode on it, and then underneath the red seal up top is my blue seal with my initials on it.
And what's in that State's Exhibit?
So State's 120 consists of items 6A and 6B.
And pull that out. So you might need some scissors and.
I get it.
Just use your teeth. Just rip it open. Spit out the extra bits. So what he did is he compared the bullet casings from the two crime scenes. One was the attempted robbery and one was the murder.
And are those little packets that you're pulling out shell casing?
Yes, these little manila envelopes are the individual cartridge cases listed. They're individually packaged.
Now, does each individual package relate back to, you see APD number 6 through 9, 12 through 14, 16, and 13?
Yes, they would.
So do they relate back?
Yes, so APD has written on these packages evidence markers numbers that they have listed there on my report, and they're individually written on each one of these, indicating which one was at which location.
And it's all those shell casings right there?
Yes, okay. All of these.
I'm going to show you what's been marked as State's Exhibit 81.
Okay. Okay.
All right. Do you recognize State's Exhibit 81?
I do.
And how do you recognize that?
So State's 81 has the GBI case number and the barcode with my seal and initials. And then I also confirmed the serial number.
Okay. And does State's Exhibit 81 have a number listed here?
Yes, it would be the GBI item number 5. Okay. So 005.
All right. Okay. And you can put those back. You can also put shelf it. Thank you. And just so we're clear, this particular paragraph, 1000207, those relate back to the murder scene.
Yes.
I'm going to hand you what's been marked as State Exhibit 122.
Okay.
Do you recognize State Exhibit 122?
Yes, I do.
And how do you recognize State's Exhibit 122?
Again, the GBI case number, the barcode, and then it has my blue seal with my initials on it.
Okay. And according to this, go down, there we go. According to sorry, we're having issues with our screen. According to your report, what were these?
So State's 122 is the evidence in that middle paragraph, item 2, 2A through 2F from the Fulton County Medical Examiner's Office.
Okay. I'm going to show you what's been marked as State's Exhibit 84. Do you recognize State's Exhibit 84?
I do.
And then can you tell us what State's Exhibit 84 is?
So State's 84 is in that third paragraph. It's from the case 33844. It's item number 1, which would include 1A and 1B.
Okay, 1A and 1B.
Correct.
All right. All right, let's go to, all right, if we can go to results and conclusions, please. Okay, so let's start with, and I'm gonna bring out a board. And Your Honor, this is going to be State's, 64A is demonstrative.
All right. Any objections to publishing 64A, Mr. Brown, or tendering as a demonstrative?
No objection to it being tendered as a demonstrative aid.
All right.
I have a copy for the court reporter as well. A paper copy.
So 64A is admitted.
Seems like an open and shut case, but every defendant has the right to a jury trial, which they might have pushed for. I don't know what his defense is going to be. Right now, it seems the best the lawyer can offer is, are you sure it was my client? But the shell casings, according to this witness, match up a known situation where his client said it was his gun that he fired. And now we've got a matching shell casings with identical tool marks.
Okay.
Whether or not you put faith in the tool mark
at
testimony, that's the different question. But in Georgia, it's
results
allowed.
and conclusions, please. If you can go ahead and we can start with results and conclusion.
Okay.
The first paragraph.
Oh, okay. Sorry. Okay, so this is a lot of technical reading I'm about to do. I'll explain everything. Don't worry. Okay. Microscopic examination and comparison revealed that the bullets, items 2D and 2E of Crime Lab case 2021-1000207 were fired from the firearm item 8 of the same Crime Lab case number based on agreement of class and individual characteristics.
And I think you said item 8. Is that an 8 or a 5 there?
Item 5, I apologize.
Okay. So at some point you were able to test the firearm that was submitted. Is that correct?
Yes. So, yes, I tested it and then made test fires of that firearm.
Okay. And then you ultimately compared that with items that came from the Fulton County Medical Examiner's Office.
Correct. Item 2D and 2E were projectiles submitted by the Fulton County Medical Examiner's Office. I then test fired the firearm, and I used those test fires, compared them microscopically, looking at the characteristics on them to those two projectiles from the medical examiner's office, and determined that they were fired from that firearm.
And according to your notes, or even the actual exhibits, items 2D and 2E, which is State's Exhibit number 122, which of those which one of those projectiles Do you know where they came from? B&2E?
Yes, specifically based on what the medical examiner wrote on the packaging, they were indicated as from the left chest and the head.
So I want to go to a paragraph, the second paragraph here under results and conclusions.
Okay.
Okay. Can you read that and explain that to the jury?
Okay. So microscopic examination and comparison of the bullets, items 2A, 2B, and 2C were all fired from the same firearm based on the agreement of class and individual characteristics. Excuse me, I'm sorry. And are consistent with being fired from a Glock 9mm pistol.
All right. So I understand that you actually received 5 little jewelry boxes. I call them jewelry boxes.
Jewelry boxes.
But one of those jewelry boxes, were you able, I guess the projectile fragment, were you able to test that?
I received 6 jewel boxes. You're good. No, 6 jewel boxes from the medical examiner's office. That 6th one was too small and there wasn't any characteristics visible on it, so I wasn't able to do any analysis on it.
So everything that you receive from the agencies, you're not always able to test?
Correct. There's some stuff that doesn't have any evidentiary value to us as firearms examiners.
Okay. So you said 2A, 2B, and 2C were fired from a Glock 9mm.
Yes.
If we could go to the third paragraph or it's actually the first paragraph on the second page. Yeah, and you can read that.
Okay. Microscopic examination and comparison revealed that the bullets 2A, 2B, and 2C were not fired in the firearm item 5 based on disagreement of class characteristics.
So those are the ones from the other gun.
Okay. So items 2A, 2B, and 2C, those 2 items that you said were fired from the same firearm were not fired from this Smith & Wesson.
Correct.
Okay. So the other projectiles that came out of the body from the Fulton Medical Examiner's office were fired from a separate gun than the one that you had.
Correct. Those 3, 2A, 2B, and 2C were fired in a separate firearm.
And just so that we're clear, you only had one firearm for testing.
Correct.
Okay. No other firearm was submitted?
No.
All right. If we can go to that second paragraph, please.
Okay. Microscopic examination reveals that the lead fragment, item 2F, was not suitable for comparison. So that 6th box that I received is just a little lead fragment. There were no characteristics. It was unsuitable for comparison. And that's all I did with it.
Okay. Thank you. Sorry, we're trying to pull it back up. Hold on 1 second.
There's a hearing right now just starting with Young Thug.
If we could please go to that third paragraph.
The new judge is asking all the attorneys to introduce themselves.
The third paragraph, microscopic examination and comparison, revealed that the cartridge cases item 6A was fired from the firearm item 5 based on agreement of class and individual characteristics.
Okay, if we could please go to, can you pull out 6A?
Mm-hmm. Okay.
And what markers, APD markers, come back to item 6A?
So item 6A is 2 9mm cartridge cases. The 2 markers associated with them based on what APD wrote on the packaging was marker 11 and marker 18.
And from your knowledge of doing this and as an expert, do those markers usually relate back to a picture, or do crime scene techs take pictures of that particular shell casing or casing on the scene?
Yes, during my training, we were instructed that when on crime scene, pictures are taken of the scenes and of evidence marker numbers.
Okay. All right, and if you don't mind, can you just
absolutely
this for a second? We can step down, Your Honor. Okay, so we were just on this paragraph here. Item 5, the firearm that we have over there, the Smith & Wesson.
Correct.
Fired 6A, which are markers 11 and markers 18.
That is correct, yes.
Okay. Now, let's, just so we're clear on this, 11 and 18 came from the same firearm.
Correct.
Okay. And we may get to it later on, but the other items in 6A, did those come from this firearm?
So 6A would be those 2 cartridge cases, and then 6B would be 9 other cartridge cases. Those 9 did not come from Smith & Wesson.
Okay, all right. And you probably need your notes, but can you tell me 6B, what were the item numbers or the APD markings that came from 6B? Or the shell casings that were 6B?
So APD had listed on the 9 cartridge cases, evidence markers numbers 6 through 9. So 6, 7, 8, and 9, 12, 13, and 14, and 16 and 17.
Okay, all right. So these shell casings here, and this one picture doesn't list all of these, right? Am I correct with that? I think it's
correct. That would be 8.
Okay. All right. But 17, you said there was a number 16 and 17 as well.
Correct.
Okay. All right. And there could be another picture with 16 and 17, but it's just not on this picture here.
It's possible. Yes.
Okay. All right. Okay. Can you go to, and I think that's the next paragraph. Can you explain to the jury what this means? Or read to the jury what that is and what this
means. Okay. Microscopic examination and comparison.
You can have a seat. I'm sorry.
In comparison of the cartridge cases, item 6B of Crime Lab case 2021-1000207 and items 1A and 3A of Crime Lab case 2021-1033844 reveal they were fired in the same firearm and are consistent with being fired in Glock 9mm pistols.
All right. Okay. Can you please go to, now let me ask you a question about your reports. You earlier stated that you usually compare everything that's given to you.
Correct.
All right. Can you explain, I think this is paragraph 6 that we just talked about, paragraph 7 on, can you explain what are your conclusions and what are they explaining pertaining to the evidence and the attempted robbery?
Okay. So the GBI, whenever we have evidence submitted, we don't separate it when we're doing conclusions, we don't separate it based on the different case numbers specifically. We just group everything together as it fits. But this portion, so after that paragraph I just read, which is the 4th paragraph, which is going to be this paragraph right here. This paragraph, anything after that is talking about the previous incident where there was the attempted robbery. All of that is talking about the evidence from that scene and how it relates to the evidence from the murder scene. Okay. So it kind of intercompares itself and then has a little bit to the murder scene.
Okay. However, do you know what case we're here on today for?
Correct.
And what case is that?
It's my understanding we're here for the murder.
Okay. All right. So you have compared some of the items from the attempted robbery, which could include from multiple firearms, correct?
Correct. Yes.
All right. With each other, you can.
Yes.
Okay.
Yes. And that's just the GBI's policy to include everything in one big report.
Okay. Based on the cartridge casings from the murder scene, how many firearms were there?
2.
Okay. All right. And based on the projectiles from the body, how many firearms were there?
2.
Okay. What caliber shell casings came from the Smith & Wesson?
9mm.
Okay. And what caliber shell casings came from the other weapon?
9mm as well.
Lots of bullet testimony here. Sorry, I'm trying to keep up to date with.
You mentioned earlier something about a NIBIN program.
And the other cases.
Yes.
Okay. Was there NIBIN? Was NIBIN used in this particular case?
It was. Yes.
Okay. Can you tell the jury a little bit about that?
So previously I mentioned NIBIN. So it's housed by the ATF, but local agencies have their own systems where they can upload images of cartridge cases from scenes and from cases. And those images are run across all other images within the system, trying to link crimes and situations to each other. So Atlanta PD, for instance, they have a NIBIN system, and they have people trained to go through those images and render potential associations or potential leads, saying that, hey, these 2 cases might be involved with each other. We should further investigate this. And based on looking at the NIBIN system at work at the ATF, I saw that the APD had done that.
Okay. All right. Were you able to further, with your particular testing, able to confirm that NIBIN, is it called a hit or NIBIN?
So they're called hits or leads. So it's just saying, hey, these two might be linked. So APD put a cartridge case. Sorry, I won't get into that. I did confirm the hit that APD made with this testing that I just talked about.
Okay. So cartridge casing from one scene with a cartridge casing from another scene, there could be a hit.
Correct. So there was a cartridge case entered by APD from the murder scene and a cartridge case entered from APD from the attempted robbery scene. They issued a hit or a lead based on those two. And then whenever I did my analysis, that confirmed that NIBIN lead.
And I just want to make sure that the jury understands when we were talking about the remainder of the paragraphs, and we're not going into too much detail, but let's go to paragraph 1. It's the 6th paragraph on here. I'm sorry, not the 6th paragraph. Excuse me, 6th paragraph on here. Here you have, can you just explain what that is and how is that not related to, I guess, the murder scene?
So the 6th paragraph here, it states what I've already described, that item 6B, those 9 9mm cartridge cases were not fired in the Smith & Wesson. And then it also goes to tell about all of the other evidence from the first scene, that none of it was fired from the Smith & Wesson. That's what that paragraph says. So it's showing that, it's just showing that connection. And it's just, again, the reason I did that was because the GBI required it.
Okay, all right. All right. However, if we go back to the murder scene, how many firearms were there?
Based on the cartridge cases, 2.
Okay, and one set of cartridge casings that you were able to examine came from the Smith & Wesson?
Correct.
And then the other set came from a Glock 9?
Correct.
All right. Okay, I don't have any other questions. Thank you.
Ms. Russell, if you could take down your demonstration.
There's our defendant.
Could leave it up for...
That's perfectly fine. All right, Mr. Brown.
Morning, Mr. Taylor.
Good morning. How are you, sir?
I'm fine. So cartridge casings were found at the scene of the murder. How many was related to the Smith & Wesson?
2.
And how many from the another weapon?
9.
9, okay. Unless someone saw a particular weapon being fired and saw the cartridge casings being ejected, there's no real way to know how long those cartridge casings was at a particular location. Is that correct?
Correct, yes. There's no way to determine how long cartridge cases had been in a location or how long between when they were shot versus when they were found.
So, as per your expertise, it's possible that, I think there was 9 that was from another weapon?
Correct.
It's possible that they could have nothing to do with the murder. Isn't that correct?
Yeah, it's always possible. There's always room for possibility.
No further questions, Your Honor. Thank you.
Any redirect?
The last question counsel asked you was about possibility, right? About those 9 cartridge casings could possibly not be from the murder.
Correct.
Okay. If we go back to let me just ask you this. Do shell casings magically appear out of nowhere?
Objection, that's vague. Magically?
Overruled. I'll allow you to take that up on cross. Like,
Can it magically appear out of nowhere?
Magic?
No.
And when there's a body in your expertise, when there's a body with shell casings, or excuse me, projectiles in it, and those projectiles haven't been fired from a Smith & Wesson pistol, which we have here, and from a Glock 9mm pistol, is it likely that shell casings will appear on the scene?
Objection leading. Counsel is testifying.
all right, Ms. Russell?
I don't think I'm leading. I'm asking him a question about his expertise.
All right. I don't think I'll overrule the objection, Mr. Brown.
Could you ask the question again? I'm sorry.
When there's a body with shell casings, or excuse me, with projectiles that came from a Smith & Wesson, okay, and body with projectiles that came from a Glock 9mm pistols, is it uncommon that shell casings will be lying around the body?
So they might not be around the body.
Hold on, just a second.
Objection. I believe this calls for speculation.
So at this point, Mr. Russell, I don't know if this is going to fall within just what he was qualified to testify on in terms of
outside his expertise,
how shell casings can appear at a scene. So maybe you can rephrase that if you'd like to.
Okay. When a Glock 9mm is fired, a pistol, Glock 9mm pistol is fired, what happens to the shell casings?
They are ejected from the firearm.
And when a Smith & Wesson is fired, what happens to those shell casings?
They are ejected from the firearm.
And sometimes they'll explain to what could happen to those shell casings.
So
when they're fired.
When a Glock or a Smith & Wesson is fired, the projectile travels down the barrel and onto the target, and the cartridge cases are ejected from the gun, landing somewhere nearby in a vicinity.
If it's a semi-automatic.
Thank you.
Smith & Wesson.
You recross, Mr. Brown.
They're not ejected.
Ms. Russell, can this witness be excused?
Yes.
Thank you, Mr. Tanner.
Thank you.
I think true crime addicts are the only people
All
on
right,
the
unless
planet
any of
that
the
celebrate
members of the jury need a
duties.
longer break. If not, state can call us next witness, but members of the jury, feel free to stand up, take a stretch break, and place if you need one as the next witness makes their way in.
Moving right along. See, the jury stood up. Now everyone else is standing up. Defendant, little yawn. His hair's gotten longer. What kind of suit coat is that? It's got like the vertical pockets. It's like a suit coat, but it has like a hoodie pocket in the front.
State may call us next witness.
Yes, Your Honor. The state calls Investigator Scott.
This is Judge Scott. I'm Scott, and now we have Investigator Scott taking the stand.
We swear affirm that the testimony you give is the truth and nothing but the truth to help you.
Yes.
You may be seated. Please state and spell your first and last name for the court.
My first name is Darline. That's Darline. My last name is Scott, Scott.
Good morning, Investigator Scott. Where are you currently employed?
City of Atlanta.
And how long have you been employed with the City of Atlanta?
28 years.
And what department are you employed with the City of Atlanta?
The Fugitive Unit.
And what unit were you assigned to back in December of 2020?
The Atlanta Fugitive Unit.
What are some of your job duties and responsibilities with the Atlanta Fugitive Unit?
My job duty is to, when the City of Atlanta take out outstanding warrants for the wanted fugitive, murder warrants, whatever the warrant is, my job is to locate the wanted fugitive for Atlanta Police Department.
And Investigator Scott, are you post-certified?
Yes, I am.
Were you post-certified back in December of 2020?
Yes, I was.
I want to direct your attention to December 16th of 2020. Did you go to the address of 1229 Kipling Street?
Yes, I did.
And what county is that in?
Fulton County.
What type of location is 1229 Kipling Street?
It's a resident with us a house.
And why did you go to this house?
I had an active warrant for Jamon Johnson. He was wanted for murder. And I also had a search warrant for that location.
And Investigator Scott, can you explain to the jury how you came about getting the search warrant for Jamon Johnson?
On December the 15th of 2020, I went to that location. I was doing surveillance. I saw the wanted fugitive in the backyard. I went and took out a warrant to go in the residence to get him.
And just to clarify, December the 15th, you went to that 1229 Kipling Street address?
Yes.
And you saw Jamon Johnson?
Yes.
Okay. Can you please tell the jury what you did when you went back to that address on December the 16th of 2020?
On December the 16th on 2020, we went back to 1229 Kipling Street. I went back with the team. That's with my fugitive team. The fugitive team went and knocked on the front door of the resident. The fugitive team called out for Mr. Johnson to come outside the house because we know he was inside. A female opened the door, and I asked her, was Mr. Johnson inside? She said yes. She also stated that my small child is inside the house. So at that time, we was able to get her and the small child out the house. I took him to my car, set him in my car for the safety, and the team continued to call Mr. Johnson out the house. And at that time, Mr. Johnson was hiding in the attic. They continued to call him. At that time, they heard he said a verbal that he was coming down. So he came out the attic.
And Jamon Johnson came down from the attic?
Yes, ma'am, he did.
After Jamon Johnson came out of the attic from that 1229 Kipling address, what happened next?
After that, he was taken into custody. He was taken down to headquarters, which is 226 Peachtree Street, and he was released to the lead detective, the homicide lead detective.
Investigator Scott, do you see the individual Jamon Johnson who was taken into custody on December the 16th of 2020?
Yes, I do.
And can you identify him by an article of clothing and where he's seated in court?
He's seated on the left-hand side. He's wearing a black suit with a black shirt, and he has dreads in his hair.
Your Honor, let the record reflect that Investigator Scott has identified the defendant.
The record will so reflect.
Thank you. No further questions.
Any cross-examination?
No cross, Your Honor.
Ms. Washington, can this witness be excused?
Yes, Your Honor.
Thank you, investigator.
Thank you.
State may call us next witness.
Your Honor, may we have 1 second, please?
Who do we have left? You an attic on the thumbnail? We're almost done with the trial. The thumbnail needs to be completed. Anything you want to add, get it on now.
Your Honor, at this time, the state would like to read in a stipulation.
And is this marked as an exhibit?
State's Exhibit 121.
Any objection to the admission or publication of State's Exhibit 121?
No objection, Your Honor.
All right, 121 is admitted.
All right. This is the stipulation of the state and the defendant. The state and defendant enter into the following stipulation. Jamon Johnson was convicted of a felony on October 5th, 2012, in indictment number 12 SC 106855 in the Superior Court of Fulton County, and on November 25th, 2020, was still considered a convicted felon. Said prior felony offenses in indictment number 12 SC 106855 involved the possession of a firearm. It was signed this 16th day of July, 2024 by me, Danielle Russell, attorney for the defendant, Joe Lewis Brown, and Mr. Jamon Johnson, defendant. State's Exhibit 121, Your Honor.
All right, members of the jury, as it relates to Exhibit 121, I do have a specific instruction of the law that I need to give you, which is that you've just received in evidence a prior conviction of the defendant. You may consider this evidence only insofar as it may relate to a required element in the offenses of this indictment, and not for any other purpose. Any further evidence, Ms. Russell?
No, Your Honor, the state rests.
All right, members of the jury, there are a few things we have to take up outside of your presence. So I'll ask you to step into the back and we'll let you know when we can be back with you.
All right, for the jury.
I believe he is in custody. He has, we'll hear, he has a list of charges. Bunch of them. Here's the cup.
All right, just as a matter of housekeeping, I just want to make sure my notes are right, so correct me if I'm wrong. But when it comes to the state's exhibits, I did not make note of a exhibit 47.
What if there's somebody
79 or 119? Just want to confirm that for the record. 47, 79, and 119.
He just smiled and waved at somebody.
Okay, the state now having rested, Mr. Brown, any motions on behalf of the defense?
Defendant Jamon Johnson, on his behalf, I move for a directed verdict of not guilty.
Any particular argument or
no argument?
Reason underlying a directed verdict in this case?
Yes, there's basically two. The state has two allegations that my client was at the crime scene committing the murder. The video of the shooters, along with some screenshots, and the ballistics, the shell casings, cartridge casings. Mr. Tanner just testified that those cartridge casings could have been there any time before the murder. So they don't place Mr. Johnson at the crime scene. The ballistics do not. Actually, there's no evidence placing the shell casings having it connected with Mr. Johnson at all. As far as the video, we saw the video. The video doesn't show anyone's faces. Whoever was doing the shooting, they were concealing their faces. So the state is asking the jury to compare a screenshot to the shooter's clothing, and I maintain that that is just not enough to prove guilt beyond a reasonable doubt. So based on that, I'm asking for the court to enter a verdict, a directed verdict of not guilty.
Ms. Russell.
Yes, Your Honor. We believe the state has proven this case at this time beyond a reasonable doubt, but I don't know if that's even the standard right now, Your Honor. As for count one murder, Your Honor, we have placed Mr. Johnson at the scene via surveillance video, via the his clothing that he was wearing, and the proximity from the first scene to the second scene. Also, Your Honor, Mr. Johnson himself in his interview stated that he was that first person on that scene. I think that could be left up to the jury to decide whether or not they believe that is Mr. Johnson in the second scene. And I say second scene, I mean on the same day, the same incident, Your Honor. And also the ballistics testing, Your Honor. Mr. Johnson admitted that he fired multiple shots on October 25th, 2020. Excuse me, October 26, 2020. And those shell casings were collected. There was, he admitted that to multiple officers. Those shell casings matched directly with the murder scene from our case, November 25th, 2020. That places Mr. Johnson there.
And remind me, was there any testimony or anything presented about whether the projectiles recovered during the autopsy could also be tested and compared to these shell casings?
Your Honor, so according to the testimony, the shell casings that were not fired from the Smith & Wesson, the other shell casings from the body, they match back up to a Glock 9mm. He's not able to test shell casings that were found.
In this particular case, they weren't able to do that.
Yeah.
Okay.
However, 2A, and I believe the other one, Your Honor, that was fired from the Smith & Wesson, from Jacob Ingram's firearm, Your Honor, matched back to obviously the firearm. Your Honor, we have asked for parties to a crime. I know Mr. Ingram is not on trial right now. However, if the jury also believes that Mr. Ingram fired his weapon, killed Mr. Carr, then also Mr. Johnson would be found guilty, could be found guilty as well. So we believe that we've proved our case, Your Honor, at this time.
I don't know.
All right. Thank you, Ms. Russell. So, Mr. Brown, I think you have outlined your arguments for a closing argument, but the directed verdict standard is to look at all the allegations and inferences and make those in favor of the non-moving party. And so here, I think there is certainly enough of the timing of the cartridges. That's a question of fact the jury can consider, as well as who it is on that surveillance video. So I'll deny your motion, but it is preserved for the record.
Yes, Your Honor.
So now we would turn to the defense opportunity to present evidence. I'll instruct the jury when they come back. The defense does not have any obligation or burden at all to present evidence, but that they can. And the first thing I think we need to take up is, Mr. Brown, you've indicated that Mr. Johnson would be the only potential witness for the defense. So now, Mr. Johnson, we've reached that point where I need to ask and go over some questions with you. All right? So he doesn't have to stand. That's fine.
Okay.
The first question I'd have before you, Mr. Johnson, is do you understand you have a right to testify? And if you want to testify, no one can prevent you from doing so. You understand that no one can make or compel you to testify. That is, do you understand you have a right not to testify? You understand that it's not your lawyer, but you personally are the one who decides whether you will testify or not. Do you understand if you do not testify, then upon proper request by you, the court will instruct the jury, your decision cannot be used against you. Do you understand if you choose to testify, you will be both examined by your counsel and cross-examined by the state? Do you feel you need any additional time to think about whether you want to testify?
Ask me if he can speak with me. Do you still I can speak with him for a second?
All right. I imagine you want more than a second. How much time do you need?
5 minutes. Just speak.
All right. We'll take 5 minutes. And are you going into the back to talk to him?
Yes, Your Honor.
All right. We'll be back at 10:35.
All right. So while they head back, we're going to skip ahead just a little bit.
We're off the record in recess until 10:35.
We're already at the state has rested. We're in the defense case. If he testifies, he's the only one that they're going to call. They don't have any other witnesses. Fast forward. Oh, they just came back. 3, 2, 1. There. Okay. Just came back. We'll bring everyone else back in the courtroom in just a moment. I think somebody's on Zoom, like a family member or a friend, right? Because he looks right there where he's looking, not now, he's talking to the bailiff right now, but when he looks down sort of straight forward and a little bit to his right, there's a monitor there. He looked at that, he smiled, and he did a little wave. Allie, this trial has a verdict. We're basically, I can assure you that we get verdict music. But I don't know what it is, so don't spoil it for anybody. Let's see here. See if I can jump ahead. Let's jump to 3 here instead. Jumping ahead just a moment. Why is there a mouse on? Oh, that's me. Still no audio. Is there audio on 2? No. Let's go to 2. I like this view better anyway. It'd be great if they turned the audio on. People are coming back in. Take your seats. Bailiff needs a break. No spoilers in the condiments. Knee-jerk reaction to whistling the verdict theme song. I don't know. I'm sitting here thinking over the state's case, and particularly the evidence they have to indicate that this is the defendant. And we have clothing that matches.
Seems to me like we would keep juror 11 for today. We could bring back the jury.
You will bring the jury.
If you will bring the jury.
The jury's like, hey, we saved some time. We've got a verdict already. I don't think I can get a poll out fast enough to see if he can testify or not. I'm a slow typer. Let me try. Sort of poll. Will defendant what's his name? Jamon testify.
Last of yours.
There we go. It's up. Got to be quick.
Here's the president on it.
You're sure about that?
Bailiff says the jurors are ready, and he says, are you sure about that? Apparently, we're still missing one. Who's he looking at?
Thank you, Deputy Scott.
Oh, it's Deputy Scott, too?
All right, members of the jury, the state has now rested and has no further evidence to present in its case in chief. I'll remind you of something that I talked about at the opening of this trial, which is that the defendant has a presumption of innocence and that he has no burden of proof whatsoever, and that burden never shifts to the defendant to prove his evidence. So what that means is the defendant doesn't have to present any evidence at all, but the defense can if they would like to. So at this point, we shift over, and Mr. Brown, is there any evidence to present on behalf of the defendant?
No, Your Honor, the defense rests.
All right. And so what that means at this point, members of the jury, is that the evidence is closed in this case. The next thing that we need to do today for you would be to prepare for closing arguments. There's something else we have to do outside your presence again, which is have a meeting about what is the law that applies to this case, and that takes some time. And so instead of starting closing arguments, stopping for lunch, and then picking them back up again, I think the best thing for us to do would just be to take a longer break for us to come back after lunch and start closing arguments at that point. So what we're going to need to do at this point is we'll break until 12:45. And so we're going to be working, and then we're also going to, we don't know how long that process lasts, but come 12:45, we'll be ready to go to start closing arguments. And after that, we'll charge you on the law, and then the case will be in your hands. Any questions for me before we break here? All right, seeing none, then we'll see you back. Ready to go at 12:45. Thank you so much.
All right, Jerry.
All right, I'm just from what I gather from this defense lawyer, I don't think he's going to have a lot of arguments to be made during this this phase of the trial where they're going over the jury instructions. I think he's pretty much just going to accept what they have. He has not been very verbose. It seems like he's almost not even invested in the trial at all, which is terrible for the defendant.
All right, let's transition to the charge conference. I believe I'm now on Courts Exhibit 4. Get a thumbs up on that. So I'm marking as Courts Exhibit 4 a compilation of both sides' requests to charge, as well as a few that I thought we want to consider as well. I've got that as a 51-page single-sided document that I'm tendering as Courts Exhibit 4, and I've also provided a copy of that for the parties to review as we go over this charge conference. And generally how I've done these, and just in the interest of efficiency, since so many of these are kind of pattern charges, is I'll just go through them, and the moment you have an objection or a concern or something you want to raise, just say it. Otherwise, we'll just keep continuing right through them. So starting off on page 1, we have the pattern charge on the indictment and instruction. And does it contain all the... I think we might need to fix something there. I don't know if that matches and tracks the charges in the indictment. Let's double check.
I don't think it does.
Right. So there's only going to be 3 counts of felony murder.
I'm a fan of skipping these parts because they're going to read these anyway, and it's going to be
and then there's 1 count of aggravated assault.
We're going to skip through
2 counts
not
of
straight. I don't think we're going straight to
felon. So we just need to change from 4 counts of felony murder to 3 counts. Is that accurate?
Yes, Your Honor.
Yes, Your Honor.
All right. I'll also note that I'm going to provide a copy of the charge that we agree on to the jury, condensed where we don't have the titles, as one 8 or 9 page document, and I'll let them know that at the outset. All right. Page 2, pattern charge of plea of not guilty.
Jump into here.
I think so. I haven't spoken to them.
All right, safety should be full shot.
Judge comes back in.
I sure do. That's going to be 5.
I think they've finalized everything now.
Mm-hmm.
C63 is probably can video.
You can just put that on the stack of exhibits that are going back.
Or sorry, on the floor.
Firearms report is up there. Because you remember I gave.
Yeah, 64.
Yeah.
Yeah, she just gave.
You know, is Mr. Brown in the back, or is...
I hadn't seen him. I was
65 surveillance video. 66 through
Say what? I didn't catch it.
70 is still shot. 71 surveillance video. 71A is compilation video.
Look at all these documents from Commission.
72 is still shot.
All these
72.
I think I missed closings. I have to go back.
Oh, the first one was
Yeah.
Well, I'm signing it anyway.
I'm signing it anyway.
Blank.
77, 78.
Sign it again.
I mean, 80 is the...
We don't have a defense attorney. I bet they'll turn on the light for us. We can give them a few minutes.
mustard. Or no, no, 82 is mustard. What's 81?
Murder weapon. Gun.
Okay, good. You have the key.
Just fast forward until the defendant comes back.
Got clock in.
85. I'm sorry.
Jane.
No.
What if I lost?
Okay.
This is at 4:15. Hang on 1 second. Let me see where this one's at.
One of the videos doesn't play. So the compilation plays. However, the video from 878 Norwood does not play. 1955 Moreland does play.
Have you been able to play those on your laptop with the same media player?
So I have, however, when they
I don't know
tried,
why they're jumping back and forth like this.
Okay, that's that. And then I have these that need to go back.
There's no defendant here.
All right, what about
this is where
this?
the defendant comes back.
The exhibit is the compilation. That does play. All right,
Sorry,
we'll
we're
take that
jumping
back up.
around. Okay. Defendant stands up. Jury's coming in. I think we're at closings right here. Struggling with his collar. He wants his collar to be popped. There you go.
Thank you, Deputy Scott. Members of the jury, welcome back. Thank you for your patience. We are now ready to begin closing arguments.
There we go.
I'll remind you, as I said at the opening of this trial, the closing arguments are not evidence, and the state has the right to open and conclude closing arguments. So I'll turn it over to the state. Ms. Russell, is the state electing to open their closing arguments at this time?
Your Honor, the state will go last.
All right. So, Mr. Brown, whenever you're ready, sir.
Thank you, Your Honor. Good afternoon. I mentioned in my opening statement that the state has to prove each of the crimes charged against Mr. Johnson beyond a reasonable doubt. That still applies. And it is our position that the state has not met their burden. The state relies on two aspects of their case to prove that is Mr. Johnson did the shooting. A video from 1955 Moreland Avenue and ballistics. Now, as far as the ballistics, you heard Mr. Tanner, their ballistic expert. The state has not proven that those cartridge casings were at the scene of the murder at the time of the murder. They could have been weeks before the murder, days before the murder. The state hasn't proved that beyond a reasonable doubt. They have not done it. So the ballistics doesn't help. So what's left is that video. We saw the video. The video does not show the two perpetrators' faces. They were concealing their faces. So what the state had Sergeant Barry testified to is that it has a still picture from the video, and it had a screenshot from a picture of my client at 878 Norwood, and basically relying on the clothing similarity. This burden is beyond a reasonable doubt because the states don't get any higher than they are right now. My client's charged with murder, 3 counts of felony murder, and some other very, very serious charges. So a screenshot and a video where you don't see the perpetrator's faces cannot be enough to meet that burden beyond a reasonable doubt. If you have a doubt in your mind, or a reasonable doubt in your mind, you have to acquit on the charge that you have a reasonable doubt about. If you have a reasonable doubt about all of the charges, you have to acquit Mr. Johnson on all of the charges. That's a high burden, and the state has not met it. So I ask you to find Mr. Johnson not guilty of all charges.
That was it. That's all defense could come up with. I guess you get what you pay for.
All right. Ms. Russell.
Yes, Your Honor.
But bring on the PowerPoint.
Jamon. Thank you for your time. Told you about cold-blooded murder in the very beginning of this case.
It's the same PowerPoint.
And you saw with your very own eyes cold-blooded murder. You saw Jerry Carr gunned down at 1955 Moreland Avenue. He was 20 years old at the time. And the thing that I keep thinking about when it comes to Mr. Carr is that he went to the store for this. That's what he went to the store for.
She brought mustard.
He went to the store.
She brought the
first
mustard.
at 878 Norwood to get this. He ran into a snake. He ran into this defendant. And unfortunately, that snake bit. Ladies and gentlemen, you always however much this costs. That. He wasn't doing anything wrong. You saw him. He was speaking to this defendant. This defendant hugged him. Hugged him. He showed him his phone. And according to this defendant, it was about real estate. And he then was bitten. He was shot 12 times. A bottle of mustard. I want to talk to you a little bit about your juror's duty, okay? And then I'm going to get into the facts a little bit more with this case. A juror's duty, all right? What is that duty? And we kept asking you these questions during jury selection or voir dire, all right? Use your common sense. Common sense, okay? We ask you to be a fair and impartial juror, honestly seeking the truth. That's it. We want you to honestly seek the truth. You are not to seek doubt. That's one thing that you are not to seek out. You're to seek the truth, okay? So what are the things that you are not to consider? Well, you're not to consider, while you're deliberating, passion, public opinion. You're unhappy with the police in general. Public feeling, sentiment, sympathy for the defendant, whether or not you disagree with the law, because each one of you all stated that you all could listen to the law and put that law with the facts and evidence and render a verdict based on that.
No jury nullification.
Conjecture, penalty or punishment, or even prejudice. That's not what you're to consider at all. But what you are to consider expert testimony, common sense, motive to lie, testimony of witnesses, credibility of witnesses, elements of the crime, defendant's actions, photos, and documents. That's what you
She had impeachment on there too.
Okay.
There was no impeachment.
I show this because sometimes we do not know the entire story. That's in life, right? Sometimes we're not going to know every single piece of the puzzle. But at the end of the day, we know what it is. And because there is a piece maybe missing, that does not mean that you cannot tell what this is. It's a $1 bill. You can tell that. There's pieces missing, you can tell that.
Yeah, but do you know
And
the
when I
serial
talk
number?
about pieces of the puzzle, I'm speaking about things like, well, why would Mr. Johnson do this? You may want to know why he did this. You may want to know why Mr. Ingram and him decided to do this after they had just spoken to this man. I can't tell you that, and I'm not going to claim that I can. We don't know. But that is not a reason. I'll get into reasonable doubt, but that is not a reason to doubt that Mr. Johnson and Mr. Ingram shot Mr. Carr 12 times, okay? So let's talk about the law.
Need a bigger font.
The judge is going to give you the law, and I'm going to talk a little bit about it as well.
For those that aren't looking, the law
But
is written in
remember,
like 180
law
point.
Plus facts.
It takes up the
You
whole
can
screen.
render a verdict based on that. The defendant has the presumption of innocence. You're going to hear that, okay? When the state rested today, that presumption has gone. That's gone. He was guilty when the state rested. All of the evidence that we have put in, we have shown that this defendant is guilty beyond a reasonable doubt. Burden of proof. Our burden of proof, we know what our burden of proof is, and we understand, the state understands their burden of proof. It's beyond a reasonable doubt. We understand that that reasonable doubt is serious, okay? But one of the things that I want to make sure you understand, that's the doubt of a fair-minded juror honestly seeking the truth. Okay? It's based on common sense and reason. And remember that. It's based on common sense and reason. It's not beyond all doubt. It's not to a mathematical certainty. It's not a vague or arbitrary doubt. Okay? It's beyond a reasonable. Reasonable being that key word. And I'm going to get into a little bit more about that. And I'll give you a little story that illustrates beyond a reasonable doubt and next, direct and circumstantial evidence. You'll get a charge about direct and circumstantial evidence. Direct and circumstantial evidence are proof of facts and circumstances, direct is proof of facts and circumstances by direct evidence. So what does that mean? All right. Direct evidence is evidence that points immediately to the question at issue. Surveillance video. You saw with your eyes what happened, what took place. Okay. You saw with your eyes. Testimony from witnesses, what they heard, they saw. Again, I said surveillance, ballistic evidence, testimony, and the ME testimony. That was direct evidence from that particular witness. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable. There is no legal weight difference or no legal difference in the weight that you give direct or circumstantial evidence. I know sometimes people say, well, that's circumstantial case. It doesn't matter. It's circumstantial. If it's proven, it's proven. Okay? Whether it be by circumstantial evidence or direct evidence. In this case, we do have direct and circumstantial evidence. There was not, and we are not claiming that there is a person who saw Mr. Johnson's face, right? The video does not show Mr. Johnson's face, and we have never alleged that. But through the other facts, through the other pieces of evidence, that circumstantial evidence, it shows that this person in the red, white, gray jacket was Mr. Johnson. Okay, so those pieces of other evidence prove it was Mr. Johnson. Okay, so I want to tell you a little story about this. Maybe you can remember it when you go back to the jury room and you're thinking about this case. So it's a January evening, and you're at your house, and you are watching television, and it's a pretty nice day, but it's cold, it's January, and you put on your television, and the newsman comes on the television and says, ladies and gentlemen out there, it's going to snow tomorrow. And you say, what? It's going to snow? It's such a nice day today. You know it's cold. It doesn't look like it was going to snow. Okay, so you said, all right, so I'm going to get snow ready. I'm going to get prepped for the snow. You let your faucets drip, but you start getting ready for the snow. You get your warm weather clothes out for the next day. You go to sleep that night. The next morning, you wake up and you say, oh, it's going to be snow out. Let me go downstairs, and you put on your robe and you head out the door. And the first thing you see when you step out the door is snow. There's snow on the sidewalk. There's snow on top of the houses. You're pretty much snowed in. You look to the left, you see snow on top of the houses there. You see snow down the street. You see a car ride by and it has snow on top of it. Okay? That car, it turned in from outside of your neighborhood. You look to the right, you see snow on top of that house as well. There's snow everywhere. So as you're going back into your house, you say, okay, the weatherman said it was snow. But then your crazy neighbor to the left looks at you and says, hey, neighbor, those aliens came down and sprayed snow everywhere last night. And you say, okay, all right, okay, my neighbor. You look to your right, and your neighbor to the right says, dang, that movie director came down here and he set up all this snow in our neighborhood. And you say, okay. You go back inside of your house, and you sit down and you're like, aliens? Movie director? Huh? That just doesn't make sense. It doesn't make sense. And you think, well, why doesn't that make sense? Well, it doesn't make sense because it's still cold out. It's the right weather, the time of year for snow. The newsman told you it was going to snow. And though you did not see it directly, right? He told you it was going to snow. And you know that maybe is it possible, is it plausible that aliens come down and spray snow everywhere? Maybe, right? But you don't believe in aliens. You know aliens aren't real. Is it possible you live in Atlanta, that movie set director made up, came and was going to shoot a movie on your street? It's possible, right? But you think, I haven't gotten any notice of this. There was a car that came from the other side of the road or from outside the neighborhood that had snow on it, on top of it. It's possible, right? But it's not reasonable. That is reasonable doubt. That is not reasonable. The aliens coming down, it's not a reasonable story. It's not reasonable because of the direct and circumstantial evidence that show you that it snowed last night. Okay, so that's reasonable doubt, circumstantial evidence, and direct evidence. Intent. So intent does not mean that you necessarily intended the result, and you could intend the result of the shooting. When you point a gun at someone, shoot it, a projectile will come out, and they may die, okay? So it is inferred from the natural and necessary consequences of the act. Point a gun at someone, shoot it, it's possible that they could die, okay? That's intent. Single witness, you'll hear about that. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there's no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. If you believe one witness, right, that is enough to find the defendant guilty. You can believe just one, right? You can find the defendant guilty based on, I believe that witness. You're going to find it guilty, okay? Party to a crime. And I want to talk a little bit about this because party to a crime concerns itself with not only Mr. Johnson, but also Mr. Ingram. Okay? Every person concerned in the commission of a crime is a party to it and may be charged with and convicted of the commission of that crime. Whatever one does, they all do. So let's say, and we believe that this is Mr. Johnson. If you believe, yep, I know that was Mr. Ingram. I know that was Mr. Ingram. You know that was Mr. Johnson. But you say, well, maybe, I'm not, they were together before, but I know that was Mr. Ingram that shot. You can find this defendant guilty based on party to a crime. Okay? So party to a crime directly commits the crime, okay? Intentionally helps in the commission of the crime, or intentionally encourages another to commit the crime. Okay? So Mr. Ingram commits the crime, Mr. Johnson does as well. Right? Ingram and Johnson acted as a team. Right? Their mission was to kill Jerry Carr, and they succeeded in their mission. They acted as a team.
Your mission, if you choose to accept.
Got into, you're going to get a charge about identity, and this is a lot to go over. Okay? But the state has proven their case, has proven identity. Because that seems to be the defense here, that it wasn't me. Right? And there's multiple ways that we prove identity. All right? Use your common sense and reason. So what are the crimes charged?
These font
Count
changes.
one is murder.
The sizes are killing
When a person unlawfully and with malice aforethought causes the death of a human being. Okay? Malice can be expressed or implied. All right? We don't have to choose one. It can be expressed or implied. It's what you feel malice, what happened here. So the deliberate intention to kill, and I'll be quite honest with you, I believe this was expressed malice. Mr. Johnson and Mr. Ingram waited for Mr. Carr to come out of that building and shoot him. This was expressed. They wanted him dead. And not only that, they shot him 12 times. Sorry, I'll go back. Malice, implied malice, no significant provocation, and all the circumstances show an abandoned and malignant heart. Okay? And so, all right, so what is that, right? It's not necessarily an ill will or hatred for somebody. You don't have to find, or you don't have to, think that, well, maybe he hated them. I think he possibly did because you don't shoot somebody 12 times, right? However, that's not necessarily malice, but it's the unlawful intention to kill without excuse or without obligation. Okay? Premeditation is not required. That's going to be some of the law that's given to you. I believe it was a premeditated crime. A premeditated murder, excuse me. No particular length of time is required for malice to be generated in the mind of a person. It can be formed in a moment, but it was premeditated, right? They got into the car after Mr. Carr walked away from 878 Norwood and got into his car and followed him. So from the time they got to their car, followed him to 1955 Moreland, got out of their car, put hoods on their head, and walked from one place to the other. That's premeditation. Okay? You'll get a charge that no proof of motive is required to prove murder. I don't have to prove the motive.
I'm hoping she ends with a screen that just says guilty across it.
So when we're talking about murder, again, I ask each and every one of you during voir dire this question. Will you be able to listen to the law that the judge gives you, the facts and evidence, and render a verdict? And we believe that you would be, and that you can do that on murder, that you will be able to render a verdict of guilty. So what do we have here? And
she went to Comic Sans.
I learned in law school. Look at the font. You take the law that the judge is going to give you, and you break it down, right?
I think
when a person, who is that person? Jamon Johnson, unlawfully, so he's not justified in any way, with malice aforethought.
Oh, man. Okay?
Express malice. That malice aforethought, remember we talked about that? What is that? Expressed or even implied. He shot Jerry Carr 12 times, implied, shot while Jerry Carr not looking and hiding out, lying in wait. Abandoned and malignant heart, right? Causes the death of a human being. Jerry Carr died from gunshot wounds. So one of the things that you do is you just break down
it's mustard and ketchup. There we go.
The judge is going to give you the law. He's going to read it to you. He's going to give you the law. Go to murder, and you plug in the facts with the law. Jamon Johnson is guilty of murder. Okay? You look at your indictment here, murder, and you'll see that the state has laid out how Jamon Johnson committed that murder. Okay? Next is felony murder. That's counts 2, 4, and 5. Some of the counts are going to be skipped because some of them are for Mr. Ingram. But then also some of them are Jamon Johnson and Mr. Ingram together. Okay? So felony murder. When a homicide is committed during the commission of a felony, must be a connection between the homicide and the felony being committed. Malice is not required. Okay? I don't have to prove the intent to kill. All right. So count 2, 4, and 5.
When a homicide is committed, affirmation counter, okay?
Right. Jerry Carr died during the commission of a felony, aggravated assault and firearm by a convicted felon. And we'll go to aggravated assault and firearm by a convicted felon, right? And we'll talk about those because if you find that Mr. Johnson committed aggravated assault and you find that he also had a firearm by a convicted felon, there's 2 of these, and Jerry Carr died while he was in the act of that, then you can find that Jamon Johnson is guilty of felony murder. Okay. So let's talk about aggravated assault because that's a predicate of one of the felony murder counts, but it's also its own separate count. Look at the indictment. You can see what he's been charged with. Aggravated assault with a deadly weapon. When a person assaults another. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to that person with a deadly weapon. You'll get language that a firearm is a deadly weapon. All right?
I can't think he'd muster.
Shot the gun at Jerry Carr. What happens when you shoot and point a gun at somebody or point and shoot a gun at somebody? They could die, all right? With a deadly weapon. A firearm is a deadly weapon. You'll get that as well. So the law plus the facts, put those together, you will be able to find this defendant guilty of that. Possession of a firearm during commission of a felony, okay? When a person has a firearm on or within arm's reach of his person during the commission of a felony. So here are the felonies that he's charged with. Did he have a firearm during the murder, during the felony murder, or the aggravated assault? If you find that defendant had a firearm, which we know he did because he shot, you can see him shoot. During the murder, felony murder, aggravated assault, you may find him guilty of this charge as well. Counts 10 and 11, last ones. And 10 and 11 are a little bit different, but they have some of the similar facts. Possess a firearm after having been convicted of a felony, okay? All right. So what we have to prove is that Mr. Johnson committed a felony. Excuse me. Possessed a firearm. But also he was convicted of a felony. All right. Here's the stipulation right here. Where he was convicted of a felony. It's right here. He signed it as well. Mr. Johnson was convicted of a felony previously, and he possessed a firearm this time. You can find him guilty of count 10. Count 11 adds on one more charge or one more element, and that is prior felony involves possession of a firearm. Okay, so his prior felony involved the possession of a firearm. It's right here. So this one is, go here. Possess a firearm, defendant had a firearm or a gun, right? We saw him with that gun in the surveillance video. After having been convicted of a felony, counts 11 and 12, defendant stipulated. Sorry, that's state's exhibit 1. Okay. So the defense's argument, I mean, his face is not shown. So what are they saying? Because your face is not shown, you can get away with murder? You can get away with any crime if you just cover up? That's the defense? That cannot happen here. That's not how this works. Maybe the defendant had a twin, right? And had on the same exact thing.
Oh, good. Introduced doubt for the jury. Great job, prosecutor. Maybe there was a twin.
Right? That means also that Jacob Ingram had a twin. Remember going back to reasonable doubt and whether
now the jury has to acquit.
Does that story make sense?
There were 2 twins.
That does not make sense.
I know twins are probable.
The defendant, the Superman, switched clothes with somebody really quick. And he also not only switched clothes with somebody really quick, but the gun that he used on the prior occasion, he switched guns. He gave him that gun, he switched his clothes, and he did it really quick. I mean, in a matter of minutes. From the time Detective Barry, and we'll talk about this, testified from the time it takes 4 minutes from the time you go from 878 Norwood to 1955 Norwood, approximately. The shooting happened around 10:05 or 10:06, and we'll go into that a little bit more. It couldn't happen.
This case just screams
Same gun
Georgia
used in the shooting before magically reappeared with a different person. So the same gun he had shot previously magically reappeared with a different person that also happened to have on the same clothes as he did at 878 Norwood. That does not make sense. Okay? Use your common sense. And then also one of the questions asked to Mark Tanner at the very end here. So the shell casings fired on the scene were there before Mr. Carr's body was shot up. Now, that is, I mean, it's clear as day that two people, Mr. Johnson and Mr. Ingram, shot Mr. Carr right there on the scene.
Going over the defense arguments.
So the story about that they
restating them
were there beforehand, that doesn't make sense. And the ballistics evidence, the evidence from the medical examiner, says otherwise.
Oh, here we go. Here we go.
So I go back to face not shown.
Murder is not a spectator sport.
Murder is not a spectator sport. People don't just commit murder.
Guys, quit watching murder. Quit watching murder, guys.
It's not a spectator sport. You cover
Shame
up.
on you. Shame.
That's what happens. So remember that. And go through a couple of the witnesses. Mr. Ayden, store closes at 10 p.m. and this is for timing purposes, right? He recognized himself in the still shots and he stated that he was scared. He testified he feared for his life because these guys hanging out at the store. He didn't want to be hurt. He didn't want to be here. Shame on yourself. Because they hang out at that store. Go through some of the clips. Jacob Ingram, Jamon Johnson turned around where you can see his gray, it's unique enough, gray sweatshirt on one side, white on the other side. Jacob Ingram. Again, Jamon Johnson, Jacob Ingram.
Employee
here.
Spelled wrong on the sign there. She just fast forwarded
And then
pictures.
this might be a video. Oh no. You have the victim speaking to the both of them. I think this is the video. And at some point, and this is in 4-speed, Jamon Johnson get out, hug him, dap him up, and they speak for minutes, at least 10 to 11 minutes. Now this is sped up. And if you want to watch the entire thing, not sped up, have at it. But it looks to be a friendly conversation. And at some point in time during this, and I'll keep going, but at some point in time during this whole encounter, you'll see Mr. Carr take out his phone and show Mr. Ingram. They'll be over here in this area. You'll see him show him something on his phone. It's probably his real estate license, like he said. He had no reason to hurt this man. None. That's Arshonda. He's the owner of 1955 Moreland. Spoke to the victim, nice guy. He had a BMW. Kept looking out the window when he bought his mustard. Okay. Thought he heard fireworks and saw two guys running away. He did not see their face. It was a holiday. Just wanted to sum up his testimony. But he got that video in 1955 Moreland. So one of the things that I thought was interesting is Sergeant Barry said that she was able to see the cars arriving. I wanted to point out those times for you, just in case you wanted to see, to go back and look at that, okay? So the victim's car turns onto Issa Drive Southeast.
Gray car
That time, 22:04:25. And at 22:04:38, the defendant's bluish gray car quickly follows but parks on the back street. So let's see. This is Issa Drive. Some point, black BMW comes along here and parks. And at some point, the defendant's vehicle parks along the street back up in here. So,
the raccoon
let's see what time I said it was. 22:04:25 is when you see the victim's car. 22:04:38 is when you see the defendant's car. 24:25, the victim's car turning.
It's just headlights.
And it'll link back up to another video. 22:04:38.
Through the bush. We're supposed to.
Look closely.
We're all looking at the shopping carts and looking for
car,
rats and raccoons.
Grayish looking
And there's
car
like
slowly parked.
something
back up
in the
here.
distance.
Sometimes need to.
Sorry. All right. 22:04:45. Again, well, 220432, first you'll see the victim's car seen on Issa Drive from another angle. But then 220445, the victim's pulls into the parking space. You can see the headlights next to that red truck. Okay. So just went by right here. And at some point, you'll see in this area.
Somewhere, something happens there. That's
car
it.
Pull up.
Right there. That was it.
You saw headlights pull up right here.
And you just assume that it's the right car. Because headlights cross the scene. Clearly, that light is only available from one BMW, right?
Ultimately, you'll see that the victim gets out of his vehicle and he'll be speaking to that gentleman in the blue. Okay. So then you see the defendants arriving. They get out of their car after they parked it, and you'll see circled each one of them coming in this area.
I've got it on the big screen, and I can see some pixels moving.
And that is Jamon Johnson.
Else.
He has on that lighter color sweatshirt. A few moments later, you'll see Jacob Ingram.
Song Chef. I have seen Bigfoot videos.
2205-45.
More clear than this.
Military time.
What I could use right now is just some huge font.
See them arrive
explaining
from this
what I'm
angle.
supposed to be thinking. Now this is actually this is good footage here. I mean this is better than most bank camera robbery footage. Assuming you can get it to play. I think it's paused, man. Okay, no, it's going now. Seconds are going. Doesn't want to get his Jordans in the puddle, so he walks around the puddle.
It's at 2206-03. Jamon arrives. A few seconds later, following behind Mr. Ingram. Lying in wait, peeking out. And you talk about malice on the phone at that. Not a care in the world about Mr. Carr.
Is he still on the phone? He's like, hey, I got to let you go. Oh.
So we know Jamon Johnson's the primary shooter because we see it, right? Oh my God. Okay. That's why I don't watch that.
Content warning. I don't know how this guy in blue didn't get hit as well. Looks like he's asking for something from everybody who goes in and out.
The car is going to walk out and is ambushed. Mr. Ingram's magazine falls out and they both take off. Okay, so identity. It's why we're here because he's saying it isn't him.
There's a big font.
Surveillance videos and ballistics. It's not just a screenshot, but it's surveillance, the entire, and all of the surveillance video. It's all of the ballistic evidence, everything. It's not just one piece of it, okay? That is the circumstantial part. You have to link it back together. It's a puzzle piece. That puzzle piece tells an entire picture. So here are some witnesses, right, to the puzzle piece. Why do we bring Sharon Latners? Well, she gets in timing. At 10:08, 8 minutes after 878 Norwood, 10:08, these are being dispatched. It's quick. It's quick. It's not a long time period from the time that Mr. Carr and Mr. Johnson speak, right? Crime Scene Tech Benson now works for Cobb County Medical Examiner. Well, he collected those shell casings in the magazine. Got to get those in, got to get that piece of the puzzle to show what happened with Mark Tanner and how he was able to test those. Again, same thing with Antoinette Green, Crime Scene Tech Green. She was able to get that Smith & Wesson firearm in that backpack along with Jacob Ingram's medicine. So it wasn't a random backpack at the random house. It was Jacob Ingram's backpack along with his medicine, right? Officer Gilbert, defendant told him he shot. Okay, need to get that piece of the puzzle in. He spoke to the defendant. The defendant said he shot at 878 Norwood in October 2020. Investigator Smallwood, again, he gets in the shell case. And the defendant also told him that he shot. Dr. Sullivan, the death was by gunshot wounds. I got to prove the death. I got to prove that Jerry Carr is dead, right? That's a part of the elements, okay? So these are all pieces to the puzzle. And when you put all those pieces together along with everything else, he's guilty. Sergeant Savannah Berry got in the surveillance videos, reviewed all of the surveillance videos. She was able to backtrack the victim's steps, again, to the previous store, had that very distinct hoodie, and she talked about that. Okay? Here it is. Defendant. I mean, all the way down to the keychain. All the way to the keychain. I mean, if you believe that what the defense is saying, that it wasn't him, that it was somebody else, that means he had to copy him all the way down to his keychain, which is, it just doesn't make sense, right? That's not reasonable. And here's the back. It's kind of blurry right there because of the pixelation, but the biggest thing is the two-tone hoodie. Sergeant Berry said this was not a crime of opportunity, it was planned. Okay, this was a planned attack. All right, this wasn't a robbery. This is something that they did because they planned it, right? That goes to the malice murder. So one of the things that we have to do when you have to do is to ensure that the statement that was given, his constitutional rights are read. Jamon Johnson's constitutional rights are read. And hopefully you all can all hear. So.
I'm surprised the judge is letting her go just over everything again, replaying evidence. Replaying. She has pop-up windows all over her computer. I swear she's got a virus somewhere.
Listen, I'm Detective Berry. Now, you was picked up by our fugitive unit. They said that you wanted to talk. Is that correct?
I'm trying to see what's going on.
Okay, I understand that, and it is going to take a conversation for you to get all of that information, but I do have to read your rights, okay? Just want to make sure that you understand this before I go out and print all this stuff and have this conversation with you, okay? So let me just read this. You can respond accordingly, and we'll just go from there, all right? What's your first name? Jamon Johnson, yeah? All right. You do have the right to remain silent. Anything you say will be used in court as evidence against you. You are entitled to have a lawyer now and have him or her present now or at any time during questioning. If you cannot afford a lawyer, one will be appointed for you without cost, and he or she may be present at all times during your questioning. You can decide at any time to exercise these rights and not answer any questions on any statements. Do you understand these rights? Okay. Do you wish to talk to me at this time without your lawyer?
I just want to know what's going on.
I understand. That's going to take a conversation. Do you want to have this conversation and speak with me without your lawyer now?
I guess I got to talk to you to see what's going on because I'm lost here.
I understand. So what I'm looking for is like a yes or no. And I hear what you're saying, but just for documented purposes, yes or no. You want to speak with me now?
Yeah, I'll talk to you. What's
okay.
Going on? What's going on?
Let me grab some stuff. It's not much longer. I've been here for a little bit. It's already.
Hey, look, they send some hands up here by me, man.
Cool.
At the house they picked me up on.
All right. So you'll get a charge about constitutional rights and whether or not they were read, right? And what was read, and whether or not the defendant waived those rights and freely spoke. Okay? Clearly he freely spoke. Or clearly he waived those rights. They were read. All right. So just want to make sure that you all had seen that and understood what was going on, specifically with that particular charge. So defendant's interview, particular, important points. He stated that he was the one in the picture on 878 Norwood. Detective Barry confirmed he was speaking about 878 Norwood.
Ingram's head right here.
Okay.
Who's this right here?
That's me.
This is you. Now.
Okay. He admitted, said that's me at 878 Norwood. 8 minutes before police were dispatched. Excuse me. At that location, 8 minutes before police was dispatched. Defendant admits to speaking with the victim on the day of the incident. Sergeant Barry states, you and the victim spoke for about 11 minutes. He admits to that.
His name is not saved in my phone.
I assume because you said he was going to help you out and get you on some path. Y'all didn't exchange numbers or anything?
No, I didn't exchange with him because we supposed to be coming back the next day and talk more business. He pulled out his phone and showed me his certificate of where he just graduated from real estate.
When did he show you that?
He showed me that day. If I'm not mistaken, that day.
This day? This is y'all right here. You shaking hands with him. Cool as shit, right? Was it that day?
Defendant admits he was at 878 Norwood. Again, Sergeant Barry shows him 6 photographs, and he says that he was shows him this 6-pack of photographs, which is Stacy 75, and he says, this is him here. He says this wasn't him here.
I wasn't doing nothing. I don't know nothing. I said this wasn't me, just trying to get you the next question. But yeah, that's me.
But yeah, that's me. Okay. So let's get into the ballistics. Not too much longer, all right? That also identify Mr. Johnson. And I'm just going to use the same chart that we've used before, right? This indicates that this gun fired these 2. And the remainder here, besides one, because one of them was not able to be tested, were all fired from the same gun. That same gun being a Glock 9mm, okay? These shell casings here match 11, I believe 18 match firearm. Remember, we have party to a crime. If you believe that Jacob Ingram fired this gun that came from Jacob Ingram's bag, then you are able to find that this defendant also committed the crime, okay? And then the last one, these 9 shell casings, and there were 2 other ones I believe that aren't photographed here, match these shell casings from the October 2020 shooting, where you can see Mr. Johnson firing his firearm and Smallwood, Investigator Smallwood, Sergeant Smallwood, excuse me, they collected the shell casings from this area and that they matched one another. That identifies Jamon Johnson as a shooter. That is enough. 9 of those shell casings, and I said this before, right, that Jamon Johnson was the primary shooter. 9 of those shell casings were from a Glock 9mm. He shot the most. His intent was to kill Mr. Carr. And then lastly, Officer Darlene Scott. She got on the stand, said he was hiding in the attic. Hiding in the attic when the police came. Why are you hiding in the attic? It's a consciousness of guilt. Police come, let me try not to get caught. Remember his buddy, Jacob Ingram, had already been arrested. He was hiding in the attic from the police. Jerry Carr, right, the son, brother, he did not deserve to be gunned down like that. Not at all. And he had so much life to live at only 20 years old. He went to the store day before Thanksgiving for mustard. At 1955 Moreland Avenue, his life was taken. His life was taken by Mr. Jamon Johnson and Jacob Ingram.
It was like a Wild West shootout.
Ladies and gentlemen, this is not the Wild Wild West.
Oh, right? Sorry.
This is not how, if there was some sort of beef, there was anything going on between them, if there was anything that they believe that Mr. Carr did to them, anything, then this is not the way we handle that. Not in Fulton County. And you, ladies and gentlemen of the jury, are residents of the Fulton County. And when I submit the case to you all and the judge reads you the law, you are the ones that will decide that this defendant committed these crimes.
I need just one big
Enough
screen
is
that says
enough.
guilty
Not in Fulton
across
County.
it for the finish. Big
Not
finish.
anymore. Jerry Carr did not deserve this. I'm asking you to hold this defendant accountable for his actions. Find him guilty of each and every count of this indictment. Each and every count.
I guess that'll do.
Thank you.
Wow.
Members of the jury, at this point, it is my obligation to charge you on the law that applies to this case. That process takes about 20 minutes. Is there anybody that needs a break before I begin that? Then let's do that. Whenever y'all are ready, we can resume. So I'll have you step in the back. And we have a question? And this is from juror number 2 for the record. Let's keep it down just for a moment. Let's hold in place. Juror number 2, do you have something you wanted to ask? Okay, yeah, we're just letting everyone go back, and we'll come back out when you're ready.
All rise for the jury.
Defense had no witnesses. Their closing was even shorter than their open, which was, it might not have been him. I would say the prosecution gave a better closing for the defense than the defense.
All right, we'll be in recess and off the record until they indicate to us. Otherwise, I imagine that's not going to be longer than about 5 minutes, so please don't go far.
Okay, we're going to fast forward. About 5 minutes, roughly. Okay, judge comes back in right here.
Court come to order, remain seated.
It's okay. Oh, I didn't have to.
That is bugging me. That light is killing me.
Oh, no. Yeah. That's what
Yes, let's go ahead and bring it out. Yeah, I went from the back to here, and I don't know if they fixed it or what they. I don't know what they're doing. I'm just going to do what I can do.
So at 1.25 speed, here's a math question for you. A 20-minute instruction should take how long at 1.25 speed? For every minute, we cover a minute and 25 of original material.
Did you want to tell me? She bad. I told you. Yeah, people got yeah, but the jury didn't get to see that big thick packet that details all your charges are.
All right, Deputy Scott, why don't you check in on them? We can just see if they're ready for us.
I look at things differently from a juror because I got knowledge and stuff. So to me, I would say no, but to these 12 people who just, I'm saying.
Came in from the bus stop.
You ready? Okay, give me 1 minute. Let's go back on the record, and I want to just address one thing with both parties before we bring the jury back in and I charge them, which is that I overheard an audible interjection during the state's closing, and Deputy Scott confirmed with me that that was Mr. Johnson's mother, and this had been someone who had interrupted us previously before at a break, and apparently she made a comment to the effect of commenting on the evidence. And this being the second audible interruption we've had, I think at this point, to prevent further interruptions and any kind of interjections which would impede the flow of this trial, that I'm going to be instructing Deputy Scott not to allow her into this courtroom throughout the charge of this jury, and if we receive any verdict. After that point, anyone can rejoin us, and anyone, of course, can watch live on our YouTube feed of anything that's going on in here. And so, Mr. Brown, if you want to provide her with that or any other member of her family, but I just don't trust her not to have some other kind of audible disturbance at this point. All right. So if there's anything else you want to be heard on that point, otherwise, she and she alone would not be allowed in until that's changed. All right. If there's nothing else, then let's bring back in the jury.
No, the judge has to tell all of this law. That read the whole thing. That's going to take about 20, 30 minutes.
All rise for the jury.
The defense lawyer is trying to give the defendant some hope. He's like, me, based on how I did, I would vote not guilty. But, you know, these 12 people, I don't know, you never really know.
Excuse me.
Thank you, Deputy Scott. Members of the jury, you are considering the case of the state of Georgia versus Jamon Johnson. The grand jury has indicted the defendant with the offenses of murder, felony murder, 3 counts, aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon, 2 counts. You will be provided a copy of the indictment and a copy of these instructions during your deliberations. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based upon the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but must also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence, nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given, and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. You may consider the legality, duration, and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made. However, under the law, in order for a statement to be excluded because of an illegal detention, it must be shown that the statement was, in fact, induced by such illegal detention. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. 1, the defendant had the right to remain silent. 2, if the defendant chose not to remain silent, anything he said could be used as evidence against the defendant in court. 3, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questions. And 4, if the defendant did not have money for a lawyer would have been provided for him to represent him before any questioning and to be present with him during any questioning. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, and that the defendant did not understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. Sometimes evidence is admitted for a limited purpose, or for some counts and not others. Such evidence may be considered by the jury for the sole issue or purpose and only for the counts for which the evidence is limited and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for that purpose. You should consider all of the factors previously charged to you regarding credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident. 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident. 3, the possibility of mistaken identification or identity. 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have. 5, whether the witness or on any prior occasion did not identify the defendant in this case as the alleged perpetrator. And 6, the length of time between the crime and the out-of-court identification. It is for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. This defendant will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such inference or inferences is a matter solely within the discretion of the jury. Every party to a crime may be charged with and convicted of commission of the crime. A person is a party to a crime only if that person, A, directly commits the crime, B, intentionally helps in the commission of the crime, or C, intentionally advises, encourages, hires, counsels, or procures another to commit the crime. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who is merely associated with other persons involved in the commission of a crime guilty of consent in or concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and possession of a firearm by a convicted felon are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon and or possession of a firearm by a convicted felon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on his person or within arm's reach of his person, and 3, while committing a felony, which is a crime against or involving another person. Murder, felony murder, and aggravated assault with a deadly weapon are felonies. The term firearm includes any handgun. For possession of a firearm by a convicted felon, as alleged in count 10, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony. For possession of a firearm by a convicted felon, as alleged in count 11, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony involving the possession of a firearm. For purposes of this offense, a firearm includes any handgun. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed, and a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. By no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous. That is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. We have compiled a verdict form, which we will include with the exhibits when we send those back to you for you to complete and to aid you in your deliberations. At this point, is there any objection to the charge as given by the state? Mr. Brown? Members of the jury, I want to clarify one aspect I said, I mentioned concerning voluntariness of a statements, and I want to recharge you on this, but by recharging you, I want to emphasize that there's no greater weight placed on this charge than any of the other charges. I think I just misspoke when I conveyed this to you. And so the charge, again, as I mentioned, concerns voluntariness and constitutional rights, and I charge you as follows. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find the defendant was properly informed of these rights and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict. All right, you may now retire to the jury room, but please do not begin your deliberations until you receive the indictment, the verdict form, and the evidence that we are allowed to share with you and provide you in the jury room. With the exception of jurors number 29 and 32, if you could stay behind with us. The rest of you may retire to the jury room.
After the jury.
Jenna Hicks, welcome. Introduced to RA because of Alec Baldwin. Hooked. Okay, Jenna, you're hooked. That's awesome. Welcome. This is a fun community. Glad you could join us and become part of that. Now you can never leave. We are glad you're here. Jenna, make sure if somebody could type !gifts in chat. Jenna, you have to make sure your gift recipient option is selected.
All right. Jurors 29 and 32, as you may have heard in the charge or just generally know, a jury generally consists of 12 people. And there are 2 extra seats in this box for our alternates, and you were previously determined to be our alternates. As I mentioned before, trials are unscripted things, and a lot of times we lose jurors throughout the week, and that's why we need to have alternates. And we still may need you. Oftentimes, we don't know how long deliberations are going to last, and sometimes something comes up where we need to sub in an alternate. So what I want to do at this point is I'll excuse you for the day. You can go home, resume your life, whatever else you had planned, but not quite yet. Don't run for the door just yet. I need to tell you a few things. We're going to call you and let you know when your service is concluded. And what I mean by that is if we need to bring you back, we're going to let you know to sub you in as an alternate. Or we're going to tell you that the case is resolved and that you're excused from your service. Until you get that call from us, you're going to remain under those 2 instructions I tell you every single day, which is not to discuss the case with anyone or anywhere, and not to do any research about the case. So if I don't see you again and you're not asked to come back, I want to thank you so much for your patience this week and for your service as jurors. All right. Thank you all.
All right. So those 2 jurors now get to go. And now we can skip the part where they're...
All right. Did we have, for the record, a final list of what will be kept back from the jurors in terms of exhibit numbers?
Your Honor, we didn't make a list of that, but
so they're going to send all the evidence back to the jury. Everyone gets up and they clear the room. They're gone. So people are gone. We're waiting. Deliberations are happening. It's like nothing's happening. Deliberations are ongoing. I don't want to miss any questions in case there are questions here. People are filing around, talking to the bailiffs. I think the judge is back. Now we're waiting for the defendant. Nothing can happen without the defendant there. Oh, here he comes. Boom. There we go. Sheena.
I can get text.
Nice.
Come back.
All right, we're back on the record. Just a few minutes ago, I was informed by Deputy Scott that the jurors had reached a verdict. And before we bring the jurors back in to deliver that verdict, I just want to say a word to any members of the gallery.
Here we are on day two. On day two of this trial, the jury has been deliberating for about an hour. About an hour is all it took. And they've reached a verdict. We don't know what it is yet. We're going to hear that in just a moment. But this case is a crazy one. Happened in a convenience store parking lot. Three people we thought were friends initially ended up being arch enemies. One of them left lying dead in a pool of blood on the ground after the other two opened fire. 13 rounds were fired, 12 of them struck the victim. He had just gone in and bought a jar of mustard. We don't understand what the motive is here. It may be gang related. This is out of Fulton County, Georgia. This is the same area where the YSL trial is taking place. They do have a lot of crime. They've got a lot of issues down there. What part of the most amazing part of this case was the closing argument by the prosecution, which she made a better closing argument for the defense than the defense did themselves. It was bizarre. At one point, I think I was believing that aliens had made it snow. It went everywhere. It was absolutely just the craziest closing ever. But jury's back. The judge is going to give some instructions here right now to the gallery. We're going to turn that on for that and listen to that. Basically, he's going to say no outbursts because, we don't do that here. And the defendant's going to find out his fate, and if the jurors believe that he was the one that pulled the trigger that night.
Which is that I understand that criminal trials can be quite emotional things. However, I would ask you to each search yourselves and decide if you were to hear a verdict, whichever way it would go, if that is something that you would be unable to prevent from saying something, from making any kind of a audible or disruption, then I would ask you to step out at this point before we have to escort you out, as we cannot have any kind of outbursts or disruptions of any kind. So with that, if we could bring in our jury.
If you will bring the jury.
They deliberated for about an hour by my count, maybe a little over. Defense closing statement was about 3 sentences long. It was short. Prosecution spent more time reiterating the defense's arguments than defense spent giving them. It was bizarre.
If it is, I'll file a motion for a new trial today.
If it is, I'll file a motion for a new trial.
Okay.
All rise for the jury.
If they didn't, I would lose my mind.
That's fine.
Just waiting for a word from you, Deputy Scott. All counted for?
All counted for.
All right, thank you, everyone. Please be seated. Members of the jury, I've been informed by Deputy Scott that you have been able to reach a verdict. And so I would ask the foreperson who has been selected among you to just rise and identify themselves for me by their jury number. All right. Now, Juror 28, were you able to reach a verdict? Was it unanimous? Has this verdict form been filled in, signed, and dated by you? All right. If you could hand that to Deputy Scott so that I may take a look.
I'm going to close out our poll here in our own little internal polling. About 88% of us said that he was not going to testify, and now 87% of us say that he's guilty as charged.
All right, ma'am. What I would ask you to do at this point is to publish the verdict by reading it out loud.
I need to count.
Yes, ma'am, from the top.
As to count number 1, murder, we, the jury, find the defendant guilty. As to count 2, felony murder, we, the jury, find the defendant guilty. As to count 4, felony murder, we, the jury, find the defendant guilty. As to count 5, felony murder, we, the jury, find the defendant guilty. As to count 6, aggravated assault, we, the jury, find the defendant guilty. As to count 8, possession of a firearm during commission of a felony, we, the jury, find the defendant guilty. As to count 10, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty. As to count 11, possession of a firearm by a convicted felon, we, the jury, find the defendant guilty.
That's 8 guilties.
Ma'am, if you could hand that
board.
verdict form back to Deputy Scott. And you can have a seat.
Subtitles were giving spoilers.
Counsel, if anyone would like to inspect the verdict form, it is available for you here.
You going to poll the jury? Never had them inspect the verdict form. While they do that, Ricky Watson, my friend, just gifted 10 Recovery Addict memberships a moment ago during our
Ms. Russell, is there any reason on behalf of the state we cannot excuse this jury?
No, Your Honor.
Mr. Brown?
No, Your Honor.
All right. In that case, members of the jury, we've reached the point where I can thank you for your service. The requirements I'd asked of you not to talk with anyone or to discuss the case, those are now lifted. You do not have to discuss the case with anyone, but if you want to, you can. And in just a moment, I'm going to excuse you so you can collect your devices, and if you need excuse letters, we can also arrange for those for you. And what I also like to do is just take a moment to go into the back and thank you for the time you spent on this case. And if you have any questions, I'd like to answer those as well. I also try to give the counsel the opportunity to come speak with you if you want to. Sometimes it helps attorneys to know how they did, if there are things that played a role in your deliberations, just to kind of draw back the curtain of what happens in a jury room. So you certainly don't have to stick around for that. You can leave immediately if you'd like to. But it is with the thanks of this court for your service that you can be dismissed. Thank you.
Rise for the jury.
Bailiffs are inching their way up.
I would have a better idea as far as grounds for an appeal. Certainly have a right to appeal. Absolutely. Yeah, you can.
All right. Mr. Brown, is there any reason we should not proceed to sentencing today?
There's no reason, Your Honor.
All right. I want to instruct the deputies, if there's anyone now that wanted to re-enter the courtroom, just the individual that we'd excluded, she's welcome to come back in.
Mom can come back in.
I'm going to take a recess here so that I can talk to the jurors and thank them for the service. Did either counsel want to be able to address them and speak to them as well?
Yes, Your Honor.
No, Your Honor.
Understood. We'll be in recess for about 15 to 20 minutes.
Let's fast forward, shall we?
Right.
Till he comes back in.
Scratch all that. Oh, that was terrible.
There we go.
I apologize.
Boom. So we go straight to sentencing. We've had hot mics throughout this trial. He's now handcuffed in front instead of in back. Some of the counts were not included because he was charged with a co-conspirator, and some of those counts only went to the co-conspirator.
All right, let's go back on the record.
Skipped some of the numbers. There were 8 counts.
Having received the verdict and dismissed the jury, believe it's been represented by counsel that we're ready to proceed to sentencing. And so, beginning with the state, do you have any? First, I'd like to hear your position on what you believe the sentence should be, as well as what merges and what vacates, and what the state is recommending. And then if you have any evidence in aggravation or argument as to why that should be the sentence.
Thank you, Your Honor. Your Honor, the state is going to be asking for a sentence of life without the possibility of parole. We believe as to count 1, that should be the sentence. It's to count 2, 4, and 5, that should vacate as a operation of law. Count 6, aggravated assault, should merge. Count 8, possession of a firearm during the commission of a felony. We are asking for a period of 5 years consecutive to the life without the possibility of parole. Count 10, we believe, will ultimately merge with into count 11, Your Honor. For count 11, possession of a firearm by a convicted felon, we are asking 15 years consecutive to count 8. So that's a total of life without the possibility of parole plus 20 years.
Why would 8 not merge into 11? So what element of count 11 or count 8 is not included within count 11?
I'm sorry, I couldn't hear you.
What element of count 8 is not already included in count 11?
I believe the possession during the commission of a felony portion of it, Your Honor.
Well, let's read the language of the indictment. A firearm during the commission of a felony against and involving a person of another, said accused having been convicted of aggravated assault. And I'd refer the state to Atkinson 301, Georgia 518.
Atkinson 301, Georgia 500?
518.
And Georgia.
This is going to reduce some of those extra years tacked on after life without parole. It won't really make a difference for the defendant, but the judge is following the law. At least the judge is arguing for the following of the law.
Firearm does not merge into conviction. No. Rather than merge into possession of firearm into the felony more amounts, the trial court should have instead merged the felon, and possession count into the relating to these.
While she's doing her reading out
possession
loud.
of firearm during the commission of a crime count into the use of a firearm by convicted felon.
Just noticed, Jenna, you got a gifted membership from Ricky. That is awesome.
I mean, well, according to this, Your Honor, I believe and I stand corrected. It clearly states that the possession during the commission count relating to use of a firearm.
No need to rush. Take your time. Take a look at it.
They're basically merging all the firearms charges into one firearms charge instead of having multiple charges. There was one crime that's committed. Okay, so if you're convicted of murder and felony murder, it's one murder. So the murder is being the bigger charge. Yeah, I believe that supersedes.
All right. Well, based on this, Your Honor, we believe that we stand corrected and that it does merge into count 11, 133. So, Your Honor, that would be as to count 8, that would merge. Count 10 would also merge. And then count 11, we're asking for 15 years consecutive to count 1. So that's life without the possibility of parole plus 15 years.
So it cut 5 years off his sentence.
I'm sorry.
Argument, evidence, deprivation.
I'm sorry, Your
like
Honor. I also do have, and you didn't mention, Your Honor, I do have a victim impact statement that I would like to the court to hear. Would you like to hear that first, or would you like to hear
whatever the state prefers?
Okay. All right. And ma'am, when you come up here, can you just please state your full name for the record?
My name is Alicia Price.
And Ms. Price, is there anything that you want me to know about what you think the appropriate sentence is in this case, and how are you connected to this case?
Well, I'm connected. I'm Jerry's godmother.
As far as the sentence in this case, I feel it's appropriate. It saddens me because on both sides, it's still a lose-lose situation. Nobody wins here. As far as Jerry, I practically raised him with my kids. He and my daughter are like 4 months apart. Same age, graduated together, grew up together with all my kids. He didn't deserve this, as was stated, and it's true. His mom died last August, waiting for justice for her son. And I'm standing here in the gap for them. The night it happened, he went to the store to buy mustard. Normally, anything he needed or anything he had a question about, he would come to me. I live across the street from them. I was hoping and, just trying to figure out why that night he didn't come to me for mustard. Since I haven't been able to even use mustard. I like mustard, Thanksgivings haven't been the same. You heard he had just completed his real estate exam, and he was excited about that because he started the process of preparing for it while he was still in high school. He was taking care of his mom. She had cancer. So he was her main caregiver. But once he was taken away, the neighborhood had to step in. He would cut the grass for elderly neighbors. Just constantly trying to progress himself to not become a victim of these mean streets.
Thank you for being here today, Ms. Price.
Your Honor, I'm going to tender into evidence State's Exhibit. I'll continue at 123, which is a conviction from October 5th, 2012. Your Honor, where Mr. Johnson pled guilty to a negotiated plea here in Fulton County. He pled guilty to aggravated assault with a deadly weapon, 2 counts of aggravated assault with a deadly weapon, false imprisonment, 3 counts of false imprisonment, and also, Your Honor, I believe that was all he pled guilty to on this case. Your Honor, I was just making sure I got it right, but according to the accusation, the one that he pled guilty to, this was for 3 different people, specifically with the aggravated assault. The state alleged that in those cases, those victims were struck on the head with a handgun. They were then tied with rope, burned with cigarettes, and then also beat with the accused hands and fists, and shooting at the feet of those victims.
Whoa.
Your Honor, that's case number 12 SC 106855.
That's his
and
previous
that's State's
conviction?
Exhibit 123. I'll tender into evidence on that one. Your Honor,
Can you tell me more about that? What was the sentence that you received?
Your Honor, the sentence on that one was a 5-year sentence that was upon 2 years service.
Well, there's
the
your
remaining
problem.
3 was going to be on probation.
So that wasn't a commuted to time served type thing. It was remitted to the Department of Corrections.
Yes, Your Honor.
And do you have any other info? I mean, other than the allegations about what that case was about or what was going on?
I don't have any other info. I see there are a number of individuals that were also charged in this crime. Other than that, that's all I have for that particular case.
All right, and that is a certified copy that you've shown to opposing counsel?
Yes, he's seen this.
All right, any objection to admission of Exhibit 121?
No objection.
123.
123, rather.
No objection.
123 is admitted for the record.
Your Honor, I also have a certified copy of a conviction out of Fulton County. It was filed in July 17, 2015. It's 14 SC 130077. It is for a violation of Georgia Controlled Substance Act. It's possession of cocaine with intent to distribute. This defendant pled guilty. He received a sentence of 10 years to serve 1 year, commuted to time served, balanced 9 years on probation. So at the time of this incident, he still was on probation. Your Honor, as far as the...
is that also something you're tendering for the record?
I am tendering that, Your Honor. That's State's Exhibit 124.
124,
The
certified
certified
copy. Any objections, Mr. Brown?
No objection, Your Honor.
It is admitted.
Your Honor, as far as the reason we are asking for this life without parole, life without the possibility of parole sentence, Your Honor, the egregiousness of these acts, the fact that Mr. Johnson, he laid in wait for Mr. Carr. Seemingly there was no reason, no justification, and with any murder, I shouldn't say with any murder, but with the murders that come before this court, we don't believe that there's an excuse or justification, but in this one, there just wasn't. The defense was identity. Your Honor, we believe that obviously identity was proven in this matter, but the fact that Mr. Carr was riddled with bullets 12 times over his body after he had just gotten a hug from this particular defendant it's unconscionable, really. So I would ask that you sentence the defendant as recommended by the state.
All right, thank you, Ms. Russell. Mr. Brown.
Is there another side to
Your
the
Honor,
story? Because this is
on behalf of my
crazy.
client, I ask that you sentence my client to life with the possibility of parole. I ask that the court shows mercy, and I can understand that the court may feel that Mr. Johnson had not shown any mercy. I'm just asking the court to show a grace that the court may not feel that Mr. Johnson showed. His family has been here throughout the trial. His mother, I believe his mother would like to speak on the issue, if she can come up.
She got kicked out earlier for making comments during trial with the jury present about the evidence.
Go straight to dinner.
Oh my God, Jesus. Judge, you want to please don't send my son away for the rest of your life. He have children. And one of his daughters sitting over there. And he have two more other kids that really need their father. And Jamon is good. He's a good guy. He's a God. Jamon is good. You don't deserve no life in jail. Have mercy on my son. Judge McAfee. Your Honor.
All right. Thank you, ma'am.
Thank you. Do you think his daughter wants to talk?
Yes.
Mr. Brown, just for the purposes of the record, could we have her full name for the record?
Oh, I'm sorry. Please state your full name for the record.
Joshua Johnson.
T-O-N-J-U-A. U-A.
Come on.
Something just fell out of the girl's sleeve. Like she had something on her sleeve and it just fell out. She stretched her hands through.
All I gotta say is,
You state your name first.
my name is Heavenly Johnson, and
How are you related to Mr. Johnson?
this is my dad.
Okay.
And I'm just here to say I love him because you can't say he does not deserve what he's getting because murder is murder. Somebody lost their life, so I can't blame it on the DA that's going against him. I'm just here to say I love you, Dad.
Would you like for him to have life with the possibility of parole? So that
What is parole?
parole is after a certain amount of time, in this case 30 years, that there's a body, a group, an organization that can determine if he could be released or not. Would you like that?
I would like for him to take life with the possibility of parole.
Thank you.
Thank you for being here, Ms. Johnson.
You are. Okay, please state your name for the record.
My name is Sharika Bailey.
How are you related to Mr. Johnson?
I'm his baby mother.
Okay.
I have 2 kids by him. Jamon, I don't, to me personally, I just don't feel like it's fair, because like, I go through stuff like that the same as well, people picking at you, and it's like, when you call it the law, I feel like it's not, they're not there until something really happens to someone. So I fear for him as well because, like, when you get picked at, you call and you ask for help, when it's there to help you. And, someone shooting at you, I'm emotional and I'm sorry, y'all. But it's I don't even know what really to say because I go through things like that too when people are picking at you, picking, shooting at you and stuff, trying to take things from you too as well. I just don't feel like it's fair for him to get life.
Would you like for him to have the possibility of being released one day?
Yes, sir.
Okay.
Yes, sir.
All right. Thank you. So again, Your Honor, I'm just asking for the court to show mercy upon my client and sentence him to life with the possibility of parole. Thank you.
Does he get to speak? He's going to appeal, so he shouldn't speak.
Is there anything else, Mr. Brown, you want to present?
No, Your Honor.
Okay. All right. So, as represented by the state, there is really only a small window of options for sentencing in this case. There's a mandatory minimum of life imprisonment. The question really just becomes whether we believe Mr. Johnson, after trial in this case, should be eligible for parole at some day. The evidence presented in this case is that, as I understand it, when this crime occurs, some time has passed. But even then, Mr. Johnson was not a young man. He's someone in his 30s. And this is not the first time that he's decided to have a gun and to use it. And even leading up to today, I just still have not heard any acceptance of responsibility for his role and what happened to this whatsoever. And I think, as the state points out, every case is a little different. But this one is a classic case of a premeditated malice murder. I think that we saw that this was something that was planned, and we saw that Mr. Johnson had every opportunity to reconsider and to choose life, but he did not. And I think that was also evidenced by the jury's swift verdict. in this case. So it certainly doesn't give me any pleasure, but I think I do feel compelled to accept the state's recommendation. And I believe, as Mr. Brown points out, that mercy should be dispensed when it's justified, when it's earned, but I just don't see any reason for that or justification in this case, especially when we see what he showed to Mr. Carr, who also should have had the opportunity to have a daughter. Speaking on his half today. So after considering the evidence in aggravation and mitigation, I'll impose the following sentence. On count 1, the sentence would be life without the possibility of parole. Counts 2, 3, 4, and 5 vacate by operation of law. Count 6 merges into count 1. Count 8 merges with count 11. Count 10 merges with count 11. And count 11 would be 15 years to serve consecutive to count 1. Mr. Johnson, I have a few things that I need to advise you of, which is that you have the right to seek post-judgment relief from your conviction of these crimes by either making a motion for new trial in this court or by filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, you need to file that motion or notice of appeal with the clerk of Superior Court of this county within 30 days. You may want to discuss this more fully with your attorney. If a motion for new trial is made and the court denies it, you would then have 30 days following the denial to file with the clerk of court your notice of appeal. You have a right to an attorney to represent you on a motion for new trial and the first level of direct appellate review. And if you cannot hire an attorney, the court will provide you an attorney and a transcript of your trial at no cost. These all being felony convictions, you have a period of 4 years from this date that your sentence in this court is entered and becomes final to file a habeas corpus petition. Is there anything else to address on behalf of the state?
No, Your Honor.
Anything else? Mr. Brown?
No, Your Honor.
We'll be adjourned.
And I'll have a question for trial.
His daughter's not looking. Not watching.
Jesus, Charles. No.
Thank you, sir.
Where'd that come from?
I'm sorry.
It was in the platform.
Yes, it is ours. Yes. Mm-hmm. Here you go. Thank you so much.
Mr. Brown, can I get those clothes on bottom here?
How does she get his clothes?
Wait. They want to wait, we can bring them back up.
Oh,
Let them know if they want to wait or not.
You want to wait?
Wait, how long? Wait, I can't tell you that. We gotta let them all the way down and get them undressed and stuff. Yeah.
Oh, yes, we got the same suit. No, but we had the same suit. We got the same suit.
Going on. We're going to bail on that. The daughter's waiting to pick up the dad's clothes. Wow, the words from the daughter. She got up and spoke at right before his sentencing. She says, "I can't say that it's not fair because murder is murder." Crazy. What's wrong with people, guys? What is wrong with people? We don't know what the motive is. We sit back here, we think the way they told us about the decedent, whose name was very seldom mentioned in this at all, but the way they told us about the victim in this case, he's like a student working hard, got his real estate license, mowing people's lawns, taking care of his mom. I know that usually once people pass, we tend to only try to speak good of them and not ill, but it didn't sound like he was that he was on the streets, living, working, whatever on the streets. It sounded like he was. I mean, he got his real estate license, right? It sounds like he was applying himself. What then brought this about? Why this? It seems senseless. And leaves a lot of questions in my mind. All right, it's time for lunch. Here's what my plan is. We have a lot of documents to read this afternoon because Monday there is a hearing for Karen Reed, and I've got 6 different documents. They're all small. Altogether, I think it's about 30 some odd pages because a lot of them are just attachments like newspaper clippings and emails and things like that. So we're going to do some readings. I think we're going to do it in StreamYard. I'm not sure if anyone wants to join, but we'll leave that option open if somebody else wants to read along with us. So we're going to go to lunch. Let's take half an hour since it's already 2:00, so 2:30 Eastern time. We'll come back. We'll do some readings this afternoon. Read some of the federal good stuff. I don't know what I'm going to read. I've got 6 documents in the Karen Reed trial, I think, that we're going to go through. Also, we've probably got some updates that are happening right now in the Young Thug trial, as that is moving forward again. They have a new judge. The judge has already sort of introduced herself, has all the lawyers have been introducing themselves, basically showing that she's the new boss around there, and get ready. So that's her right there.
State's table right now.
I won't show her, but she's trying to learn it. The attorneys had to say, hey, this is what the rules are. Remember, when one of us makes an objection, it applies to all of us. But she's trying to get this all set up and get this begun again. And as you know, it's a courtroom full of lawyers with lots of motions. No defendants there yet, so she's, at least none that I can see. Looks like lawyers only. There's Mr. Steele as well, but good stuff. So we might take a look at that as well. So Young Thug back on the schedule. And other than that, we're going to take a break for lunch. I'm going to have just a bite to eat. We're going to come back with my best reading voice ever. We're going to be on StreamYard. So if you want to join us on StreamYard, all we ask is that you have good audio. We need some video. We need to know who it is. I can't just let anybody on. And we're just going to I'll only have like one other person on at a time. I'm not going to have a screen full of people reading because that gets confusing. But that option's out there. Otherwise, I'll read them all myself. So not a problem there. Chicken salad on toast sounds mighty good right now, Susie. Just send me the address to the burner phone. I'll be right there. Sounds delicious. I think I'm going to have leftover Hawaiian pulled pork. I think it is. I don't know what else to call it. But. All right. Thank you very much. Thanks for enjoying this trial with us, a 2-day trial out of Fulton County, Georgia. So much is wrong in Georgia. So much is wrong. We know that we've got internet issues affecting both here on our channel with some of our functions not working. I think that's because of the glitch. All the airlines are down because of the glitch worldwide. Yeah, it's bad. Not all of them, but the big ones. So Fulton County has had glitches before glitches were a thing. They got hit just a couple months ago. They got hit with a virus. Somebody within their county opened up an email they shouldn't have opened. It encrypted their network systems. It encrypted everything, and they were basically told they had to pay a whole bunch of Bitcoin to get the encryption key back so they could access their own stuff. They went months working on paper instead of using computer systems. They have struggled with these, so today's our day to have that as well. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe to go live again in about half an hour with readings for the Karen Reed trial. I'll go ahead and make the thumbnail as soon as this one ends. Had I thought ahead, I would have made it right now, but I didn't, so let's see how fast I can do this. Let's see, Karen Reed. I'll change the thumbnail, I'll have to rechange this. New docs. There we go. All right, I'll have a thumbnail ready for us. Guys, we'll see you in just a little minute. There might even be a portal. You never know. Wait for it. I'm still building the portal. Hot mic, still here, still here. I'm going to disappear from the camera for just a second. It's almost like we need like more music, a longer version. Not a camel. Redirect. And all right. The picture's wrong, but we've got new docs. there you go, guys. See you after lunch. Bye.